Tranter on behalf of the state of Ohio. We're here for sentencing. So everyone had an opportunity to review the pre-sentence investigation.
Yes, Your Honor.
Ms. Tranter, anything on behalf of the state?
No, sir.
Anything from probation?
Nothing further, Your Honor.
Ms. Chambers?
I have discussed the recommendations that we discussed in chambers with Mr. McCourt. That was what he pretty much wanted all along, so he's very much in favor of that. He has been proactive in getting his own treatment. He was approved for Genesis even before I was involved. And over the course of this, while he's been waiting for sentencing, he has been trying to take care of the other warrants and the other active cases that he has. So he very much wants to put this case in particular beyond him and move on.
Thank you. Mr. McCourt, is there anything you'd like to say, sir?
No, I'm just ready to get this passed and get on my road to recovery.
Okay. Court's considered the statements made here today, the pre-sentence investigation, the purposes and principles of sentencing, the relevant seriousness and recidivism factors. Mr. McCourt, I am going to give you the opportunity to get your life back. So I'm going to place you into community control for a period of 3 years. You will be subject to the supervision of the Warren County Probation Department. You're ordered to refrain from the use of any drugs, alcohol, or marijuana. Do you understand?
Yes, sir.
All right. Now, the level of care that you have been indicated necessary is inpatient. So I am going to approve you into the Genesis program, order you into the Genesis program for substance use and mental health treatment. I want you to complete the Thinking for a Change class and the theft class. You're to have no contact with the victim in this case. Do you understand?
Yes, sure.
All right. I'm also going to have you triage for Judge Peeler's recovery court. I think that extra layer will help you based upon your prior record. I think it's necessary that you have as much services surrounding you as possible. So I'm going to order you to at least be triaged for that. I'm going to order you to get your operator's license valid. I know that's going to be a long road for you because you have a lot of outstanding stuff that you got to take care of, and we're going to start on that stuff today. Ultimately, when you are ready, I want you to get full-time verifiable employment.
Yes,
okay? No more working under the table. Okay. Looks like you have 79 days jail time credit as of today. Now, you're also subject to a discretionary period of post-release control, which means if you are sent to prison on this case, when you are released, the adult parole authority may supervise you for up to 2 years. If you violate that supervision, you can be returned to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you could be returned to prison for 1 year or the period that you have left on PRC, whichever is longer, and that time would run consecutive to any additional prison time you get sentenced to. Finally, I'm going to find that he's indigent today for purpose of any fines, costs, or other financial sanctions. Finally, you do have a right to appeal the court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, including an attorney, that can all be provided to you at no cost. Do you have any questions for me?
I don't think so, Your Honor.
Got a long road ahead of you, but we're going to try to give you as much support as we can to get your life back, okay? Ms. Tranter, is there anything else?
No, sir. Thank you.
Ms. Chambers?
No, Your Honor.
All right, good luck to you, sir.
Thank you.
Thank you.
Appreciate it.
I just released him. He's got some warrants to take care of, and we're going to release him. And
Can he pay all this today, Mr. Godfroy?
Yes. Yes, Judge.
Okay, so you can come up here, you can talk to him about that, and we'll go from here, okay? And I'm talking about, you can talk to them about who your therapist is and make sure that's good with them, all right?
Okay. Thank you, Judge.
Thank you very much. Beth, I'm going to need the screening report on that case.
Just a little back for you, Judge.
Oh, you did? It's in there?
Yes.
Perfect.
Yeah.
Good. Okay. I'm gonna try to, let's get that one done. Mullhern, William Mullhern, William Walter Mullhern, 2483 Field, 54. Your name, sir?
William Walter Mullhern.
Elizabeth Watch,
So today is the date scheduled for a probation violation hearing. And the charge is that you failed to submit the twice weekly chemical testing on April 4th, 26. Count two, you failed to refrain from consuming drugs, testing positive for cocaine on April 6th of 26. Those are the two charges. If you plead guilty or if you're found guilty, in that event, your probation could be revoked and you could be incarcerated for 45 days. Do you understand that?
Yes, sir.
Did you sign, read, and understand the advice of rights? If you plead guilty, you'll be giving up all those rights and we're not going to have a trial of any kind. Do you understand that?
Yes.
You have the right to an attorney. I'll be happy to provide you with one right now at public expense. Are you sure?
Yes.
You sure you don't want one?
No, I did this one.
All right. To the charge, you failed to submit the twice weekly chemical testing on April 4, 26. How do you plead?
Guilty.
Did you fail to submit the twice weekly chemical testing on April 4 of 26?
Yes.
Count two, you failed to refrain from consuming drugs or alcohol, testing positive for cocaine on April 6 of 26. How do you plead?
Guilty.
Did you test positive for cocaine on April 6th?
Yes.
And had you used cocaine, say, within the preceding 3 days? 3 or 5 days?
Yes.
Anybody force you to plead guilty?
Oh, got angry.
What's that?
I got angry. I got my truck outright. So somebody hit it in the street. I'm
I'll accept your pleas. This one pains me. You ran a marathon, you got to 500 yards away and you stumbled. And then you got 40 yards from the finish line and you quit. I don't understand.
I didn't put everything out there. I shouldn't have held on it back. I have a lot of, my doctor thinks I need to be put on psychic meds, but it's from when I go to my meetings, I don't tell everybody everything. You ask me what's wrong and say I'm fine because I don't want, I'm not fine. I'm going to listen to the doctor and get the meds and keep continuing what I'm doing. I got angry. I've had it my whole life, but I never thought when you go to an ending, you need to die. Just didn't want more drama. Now, watching her for the last 2 weeks being, I take care of Ginger, you know,
I know.
and now I'm leaving her a spot because of me. It is. I'll make it fun here. I come a long way, Judge, but I'm not where I want to be at. I don't know. This can't happen. I just think I get too overwhelmed and I'm dealing with it.
I don't know what I can add. This is one of those cases where I wish we had more than 2 years, Judge.
So,
But his expiration date, I believe, was April 10th. So we are obviously past that as far as decisions to be made. He complied all the way to the end with the exception of these 2 violations. I received updated proof of treatment. As you're aware, he was here yesterday for status review. We're just in a position where we're out of time at this point. And obviously cannot graduate him based on sobriety.
What did you find out about what I asked you?
So I did look into several places. Bill is not good with voicemails and emails. Couldn't get from him the information I needed as far as when it would come to insurance. And I think it changed thinking this was a 90-day misdemeanor. It's a 45-day
Right.
misdemeanor based on our conversation. I spoke with a former graduate of the program. I still think this is a great place if inpatient is an option. Is Sobriety House off the West Grand Boulevard, but they don't offer jail transportation. I think getting to know Bill for 2 years, this is the appropriate place for him, as opposed to the places that do jail transportation.
Sobriety House where?
West Grand Boulevard, New Jersey.
But we have to make sure he's got the insurance coverage.
They should be okay. I can have a conversation with Bill after this. I can call over based on what their funding is. They may have him go through DWIN. They may have him go through his insurance. Again, I was at a bit of a loss with that information.
Say something.
Sure.
My insurance, I'm almost done with it. They're gonna charge me $2,000 a month or $1,800. After this, I got one more month left, but I have to take my first. Or and then I'm done with my insurance through the union for retirement.
So he might be able to call DWIN and then DWIN would dictate where he
I
goes.
think we can take care of that right now and find out.
Oh,
And
absolutely.
I'm not guessing. Why don't you two go take care of that? When you're ready, come on back in and I'll take care of this, okay? I'm accepting your guilty pleas. Yeah, we'll go from there. All right, thanks.
Thank you, Judge.
Mike or Jeffrey Teets, 26F2640001B.
Good morning, Your Honor. The active TOP 82378 on behalf of Mr. Michael Teets.
Michael Feets.
All right, so I want to make sure, is there a Jeremy Roos here by chance? Jeremy M. Roos, is he either here in person or on Zoom? Heather?
I do not have him on Zoom.
Insurance rights notice was mailed to him on March the 20th, advising him of the sentence date. I've not heard anything. He's not here. I don't have a victim's rights statement. I did read the report. Have you had a chance to review the screening and assessment with your client? And are there any material additions, corrections, or deletions?
We did review the report. There are no additions. Those are correct.
Is there anything you would like to say in his behalf?
Yes, Your Honor, he's apologetic for the situation. He has job prospects, Flat Rock Metals. He's waiting to determine if they're going to hire or when he can start. He also had another job prospect, which is AFM Heating and Cooling. They offered a job. He's waiting to determine what Flat Rock Metals is going to do. So, Your Honor, I would just ask if the court would adopt probation recommendation.
Anything you'd like to say, sir?
I'm very apologetic what happened. Will not be faltering any further. A huge lapse of judgment and wholeheartedly sorry.
Your Honor, he also is attending AA. He emailed his sheet to probation. He goes twice a week. The last time he went was yesterday.
And then I had one done on this record.
Kind of alarmed by some of this. I mean, the way I read this whole report, you're in there, you're threatening this guy, the manager. Why is he coming after you? Why is he following you? You got a machete there. You look at him in a threatening manner.
I was scared, but
Scared? Why?
he was in plain clothes and didn't have a name tag on. He followed me around for 15 minutes. And then when he got within a foot and a half of me, I turned around and that's when I shouted at him.
You ever had not being flippant here, have you ever had a psychological evaluation at all?
No, sir.
Why were you so angry? If you weren't doing anything wrong, why were you so angry? So what if they're following you around?
It was a lapse of judgment. I'm not a confrontational, doesn't act like that in a moment.
12 months probation. You cannot leave the state without consent of the court. You cannot violate any law or ordinance of any unit of government. You change your address, your place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no illegal drugs, no marijuana, no marijuana. You understand that?
Yes, sir.
How much did you consume?
I had full endurance.
No alcohol, no marijuana, no illegal drugs. I want you to submit to chemical testing, PBTs and ETGs bi-weekly for 3 months. If you're clean, I'll make it then monthly. Okay?
Yes.
Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. I'm going to order that you continue to attend AA, NA at least twice a week. Until you're in outpatient treatment, you sign up before and you get into outpatient treatment, you don't have to attend AA or NA any longer. You're not to enter or go near 26100 Vreeland in the city of Flat Rock or any other Meijer store. No contact with Jeremy Roos, no firearms, no dangerous weapons. You're not to possess those. Do you fully and completely understand that?
Yes, sir.
So you're going to do outpatient, you're doing AA until you're outpatient, you're staying out of that Myers and every other Myers, AA twice a week, like I said, until an outpatient. No firearms, no dangerous weapons. You're not to possess those. You're not to have any contact with Jeremy Roos. I'm going to order, I'm just troubled by this, though. You didn't brandish the weapon. But nonetheless, you had it on you and you're creating a scene. 4 days court work program, $35 a day charge, total $140. Fines $100, costs $150, 75 victims' rights fee, $50 justice assessment. So your fines and costs your amount to $375, screening fee $60 for $435. You have $240 worth of court probation fees for a total of $675. And then $140 of court work program fees. Your total's $815. You pay that, you stay out of trouble, and you're eligible for early discharge after 6 months. No contact with Jeremy Roos. We understand one another, right?
Yes, sir.
So if you do everything in 6 months, you can make application for early termination. You're entitled to that by statute if you haven't had any other violations. All right. I'm kind of worried about what's going on with you, though. You got you had a impaired 2 years ago, drunk and disorderly. It's just, this is not good. Can I ask a question?
Yes, sir.
You had another drunk and disorderly here, right?
Yes, sir. Well,
Within about 10 days, right?
yeah,
Where was the other one? In front of Judge Hessen or me?
that's it.
Okay. Can he pay all of this?
No, you're already payment plan.
How much can you afford to pay weekly, bi-weekly? You tell me.
Bi-weekly, I would say around $100.
I'll make it 50.
I really.
And you can start beginning on May the 15th. We'll make it May the 18th. If you ever reach a point where you don't have the money, it's not a problem. You just call the court or come in here on or before the due date. I'll give you an extension. You'll meet with probation. If you violate, your probation could be revoked. You could be incarcerated for 90 days. You have 21 days to appeal, and you have 14 days to apply for a court-appointed lawyer for purposes of appeal. Do you understand that?
Yes, sir.
All right, you'll meet with probation. I wish you well. Thank you, Ms. Patillo.
Thank you.
Have a good day. Valacor Environmental Services LLC 26B 150652. Good morning, Mr. Youngs. Your appearance?
All Youngs on behalf of Valacor, Your Honor.
All right, so this can be a plea to overweight. You have authority to do this, and there's agreed upon fines and costs of $4,200. True?
Correct.
On behalf of the company, to the charge of overweight, responsible or not responsible?
Responsible, Judge.
Accept the plea, $4,200. Fines and costs are due on May the 15th, okay?
That sounds great. Okay.
Have a good day. Thank you.
Bye, Judge. Great seeing you.
You too. All right, let me take Taylor Rettinger. Taylor Rettinger, 26R514588. Your name? Taylor what?
Taylor Rettinger.
You're going to plead to impeding traffic, right? They got you going 92. You're going to slow down, right? I mean, that's kind of quick. To that charge, impeding, responsible or not responsible?
Responsible.
I'll accept the plea, dismiss the speed on their motion. 150 fines and costs. You're all set. Go down. I'll take care of that. Best of luck. Slow down. Thank you. Haley Aston, 26R514568. Good morning, ma'am. You can step up here. Tell me your name, please.
Aspen?
You're going to plead to impeding traffic, correct? You met with the department rep, and that's what you guys agreed upon, true?
Yes.
To that charge, responsible or not responsible? I'll accept the plea, dismiss the speed, 150, and you're all set. Good luck. James Robert Adams, 25B8PV708. Good morning, Mr. Adams. How are you? How are you? Good. Your name? James Robert. All right, I'm just going to ask you to raise your right hand, please. Does somebody swear affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole true self you got? Yes, sir. Since you were in court on April 4 of 25, have you been arrested for any reason? No. Any new charges? No. Any contact with the police? No. Congratulations. Prosecutor says he moves to dismiss. As you complied, case dismissed. Good luck. Have a good day. You too. Great. Shunky. I don't know if I'm pronouncing that correctly. Sharon Michelle Shunky, 26F2457128. Morning, Mr. Haynes.
Morning, Josh. And please, the court. I'm John Haynes.
How you doing?
Good.
She's coming up with a smile. Your name?
Sharon Zunke.
All right. So your client pled guilty to operating while impaired. The OWI was dismissed. She was referred for a screening and assessment. Have you had a chance to review the report with her, and are there any material additions, corrections, or deletions?
Just one minor correction. She said it was Benson Romulus. It says Taylor in the report.
Okay.
Everything else is the same. Judge, the recommendation is appropriate. I know our legislature looked into these sorts of offenses as to whether they should be probationable or not. In this case, Ms. Zunke's 46 years old. She's got a record and the let out 20.12. This is a two garden variety case, and the report doesn't uncover any kind of long-term issues without color trust. I'd ask the court to consider just fines and costs, but in the alternative, hearing, thank you for the recommendation.
You never been in trouble before. And I mean, there is a presumption I'm not supposed to put her on probation unless I think there's reasonable grounds, good grounds to do so. You want to say anything, ma'am? And I think she's pulled over because of expired tabs, not because she was crossing the fog lines or anything else.
That's my point. I see these kind of cases, if not one like this, then what did they mean?
I disagree with you. You want to say anything?
No, I'm sorry.
I don't disagree. I mean, I don't necessarily think they should be telling us, but whatever. That's neither here nor there. 300 fines, 300 costs. 75 victim's rights fee, $50 justice assessment, $60 screening fee. That is $785 plus you have rest of cost of recovery of $150 for a total of $935. I'm gonna order 2 days jail credit, one serve one, and I'll let you do that by way of community service. So you do 1 day of community service, ma'am. I mean, I don't disagree with you at all. I'm not saying I necessarily agree with it, but you're right. So you do 1 day of community service, and I'll give you until June 1st to complete that. So you pay your $935, do 1 day or 8 hours community service, and you're done. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal if you cannot afford one. Do you understand that?
Yes, Judge, I think your question's the first paper facts.
That's fine. I just want to make sure. Do you understand the sentence?
Service?
1 day of community service, fines and costs of $935. That includes everything. You understand all that?
Yes.
And you understand if you don't do your day of community service or pay your fines, that you should receive 93 days less the credit for 1 day served. I can't hear you.
Yes.
How much do you have? Does she have anything today?
I don't think so, Judge. We were thinking on to the month starting there.
Can I ask you a question, ma'am? Why aren't you acquiring some work?
I am looking for work here. Awesome.
I'll let her pay $100 per month. We'll start that beginning on May the 5th. How's that? If you don't have the money on any given date, all you have to do is come in and talk to me on or before the due date or call the court. We'll go on Zoom if you know how to operate Zoom. And I'll be more than happy to give you an extension. Okay?
Yes.
I wish you well. Good luck. Thank you. Alicia Leanne Young, 25B7186119SD.
Morning, Your Honor. The applicant TOP 8237A on behalf of Mr. Alicia Young.
Ma'am, your name? All right, so your client has no priors. I mean, she had a case that was dismissed under HIDA, and she does have a warrant. Why hasn't she surrendered herself on a warrant, ma'am?
I came last week too.
No, to Grand Rapids. She got a warrant out of Grand Rapids. You need to surrender yourself on that.
Oh, wasn't aware of that.
Okay. So she pled guilty to operating while impaired. The thing that really troubles me is you had 3 kids in your car and you're drunk driving. You know what I'm saying? Is everything in this report accurate?
Your Honor, one small correction. It looks like that sentencing date says January 2026. It should be April 16, 2026. I did discuss that with Ms. Young as to why she had failed to appear. She had a domestic violence situation, and then she did.
She wasn't here at the court to school program. She didn't bother showing up for that, which didn't excite me, but.
That was when she was relocated, Your Honor. Like I said, she was in a domestic violence.
I got it. So I'm not sure. What are you talking about where it says the sentencing?
At the top, it says, I think it says January 16, 2026. It's the sentencing date.
She was supposed to do January 27, 26 at the court to school program. So.
Well, it says January 6, 2026 on a pre-sentencing. For the sentencing date.
Wait a minute. Well, let me back up here. I don't know where you're talking about. Oh, sentencing date, January 6th. I don't know why they had that. I think it was a typo. They should have had January 27, 26. They should have. But I made a mistake already because the plea wasn't to impaired. It was operating while intoxicated. It's just to make the record clear. She pled to 1 count and the OWI occupant was dismissed, 2 counts of that. And actually 3 counts of that, and they reduced it to OWI. Period. OWI occupant less than 16, ma'am, is a 1-year misdemeanor under state law. You can't do that, okay?
Yes.
Yeah. Anything else?
So, Your Honor, she did indicate to me that everything is finally coming together. She got out of that domestic violence situation. She said she finally has help with her children. She's still employed, but because she has 3 children, Your Honor, she doesn't earn a lot. So I would ask if the court can waive any discretionary fines and costs. She's also been attending AA. She has it on the phone.
Okay, so now
Last day she won't say.
why didn't you listen to me? I told you to go in person, didn't I?
It was just a picture.
It's just a picture of the count that she gets signed.
Yeah. I do go in person.
Where'd you go?
I go sometime to Taylor with my sister at the little church. I'm not sure exactly what, because it's like a .gov. And then sometimes in Westland in the church as well. St. Paul Lutheran Church in Westland, so I go for that one.
Anything else you would like to tell me, ma'am?
I'm just trying to get on the right path. That's all. Everything I got from home, relocated my children. Just trying to keep going and doing the right thing, getting the wrong people out of my life.
Well, that's a good thing. Can't have bad people that we're close to, right?
Yeah.
I don't want to keep repeating myself. But I am concerned about you driving around with kids in the car. 12 months probation. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, place of employment, or home telephone number, you must notify probation immediately. You do have to report as directed. No alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any one of those. You're to submit to chemical testing, PBTs and ETGs. I'll make it bi-weekly for 3 months. If you're clean, I'll then make it monthly. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. I'm in order that you attend AANA. Continue doing that twice a week until you get into, and I'll go along with that, the level 2 alcohol education program. I don't know if this is, according to the report, I mean, I have no reason to dispute that she does not have a serious alcohol problem. But it's decision-making, I guess, that bothers me the most when you got kids in the car and you're driving around like this. I do want you to obtain and maintain employment, provide proof of employment. Again, I'll go along with the level 2 alcohol education program with the victim impact panel. You declare all warrants within 15 days, but you need to get employment, okay?
She is employed, Your Honor.
I know she is. She's employed full-time, but I'm trying to tell her she needs to get a better job. I don't mean to disparage this fast food restaurant. I don't know how you're going to support kids when you're making $300 a week. So I'm just telling you, if I were you, you have to maintain employment, okay? You have to maintain employment. I'm encouraging you to get better employment. 4 days jail credit, 1 serves 3. I'm going to have you do all 3 on the court work program. There's a $35 a day charge for that for a total of $105. So 3 days court work program, 300 fines, 225 costs, 75 victims' rights fee, $50 justice assessment. So your fines and costs alone are $650, screening fees $60 for 710, probation fees are $240 for 950. You have cost of recovery of $150 for 1100 plus your court work program fees, totals $1205. If you violate, your probation could be revoked. You could be incarcerated for 93 days. You'll have 21 days to appeal, and you have 14 days to apply for a court-appointed lawyer for purposes of appeal. Do you understand that? You may be eligible for early discharge. How much can you afford to pay? Can you pay $50 or $40 biweekly?
Yeah.
That isn't going to be enough. I'll tell you what, we'll start with $40 biweekly I'll start that beginning May the 4th, but all money due by March 15 to 26. But I'm not going to discharge if you don't have all your fines paid, okay? You understand that?
Yeah.
Again, you have 21 days to appeal and 14 days to apply for a court-appointed lawyer for purposes of appeal. And again, your probation could be revoked if you violate. I wish you well. Do you have any questions?
Nothing.
You'll meet with probation. Thanks, Ms. Patillo.
Thank you.
Walter Mullhern, 24WA33054.
A little bit about patient, Your Honor.
Name?
William Mullhern.
What'd you find?
I could not find out anything, Your Honor. Bill is very difficult to work with. I'm trying to explain things to him. He's got far too many questions that dictate what's going to happen to him and concerns for his girlfriend. I cannot get a straight answer from him. I try to be firm with him to the point where I got to the point where I just said he needs to leave my office and that we.
Hang on a second.
All I want to find out is if I don't have enough wallet on my clothes, my sister has a child. If I can go home and get this stuff to come back and all, I'm not running. I'll go to the vote. I'm willing to get the help.
Bill.
I don't have anything. I don't know if I can take my phone.
Why did you come to court today?
Because I thought I was going right to jail, and I didn't want to lose it down there. It's all I had. I'll do whatever you say, Judge. I mean, you know who I am. I'm not running. If I can get in this program today, I'll go down there for you.
My intention was to give you some jail time and then let's just allow you to serve some of it inpatient. That was my intent.
There's no way I can do community service. And
Shit, Bill. You spent 2 years.
I understand. I just didn't let everything up. Sorry.
You violated probation.
I understand.
You can't get, you didn't get to do probation. I don't understand why you did this to yourself. I can't just let this go. You've got a horrible record. I mean, I can look at it in a positive light and say, well, it wasn't a drunk driving. Well, it wasn't assaulted. It was, your lawyer did a good job getting it pled to attempted possession of cocaine, which is only a 45-day misdemeanor under law, under local ordinance.
Can I go pay my insurance? So I have the full insurance for it and go turn myself into this program. That's all I'm saying.
You go pay your insurance. How long is that going to take?
It's in Troy. I will, if I can get the number from them, I'll stop there and make arrangements and have the insurance all done. It's the only way I can get the insurance and I don't have to worry about the state insurance or anything. And I need to be able to get my meds. They're at home too. I will go, Judge, I'm not running. I'll do whatever they say. This program saved my life. They wouldn't be alive before it. He's had 5 surgeries. If you would have put me in there, I would have never been any further. I know I ain't sober all the way. I used to do this stuff 40 times a year. I come a long way.
You used to do this stuff when?
I want to be completely clean.
Well, I want you to be completely clean. That's why we got you in the sobriety court.
This stress the last 2 weeks and looking at her face. What I did to her is horrible. It's unforgivable.
This is painful for me.
It's painful for her. I deserve it again.
I didn't say I wasn't sending you to jail. I want to be clear.
I understand. Whatever you say, I trust you. I did this.
Can't you just make your payment by phone for your insurance?
They don't do that. It takes them 10 days to process it. Even just every month I go to pick my meds up, I got to call the union hall to have them approve that program. They say it's completely.
Why are you giving Ms. Wilds a hard time?
I'm not. I tried to talk, but she just wants to. I know she's trying to help, but I'm trying to make sure I have everything straightened out when I get there so I don't have to worry about this insurance. I usually pay it before the end of the month, but if I got to go today, I'll go pay it today. Can we come back tomorrow and I'll take care of everything?
Going to a funeral tomorrow. I can't be here.
Whatever. I'm just trying to do whatever makes.
Who's this?
It's Mr. Simpson today.
She wouldn't even let me around her house for 20 years till I got this program. Okay, this program took me a long way. I was very sick.
Could I say something?
You'd have just shown up for graduation.
No, but listen, I needed more help. I was scared. You always said the 2 years. I was terrified of it, okay? I was terrified of going out there and using them. I didn't let everything out, and I didn't know how to explain it. I could talk to Emily. I can't ever get a hold of her. I don't know how to email. I don't know how to do any of it. I don't know how to Zoom.
All right. Okay, slow down. Just slow in.
I go.
Ma'am, you can't. Okay.
I don't want to use somewhere, Judge. Save my money.
What do I have going on Monday morning, Heather? Do you know?
Monday is your landlord tenant day.
Today's the 16th. 17, 18.
I'll do whatever you say.
April 20th, you'll be back here at 8:30 in the morning.
On Monday?
On Monday.
Now, do I need to contact the court or anything? I'll let her talk.
You need to get your insurance
Okay.
taken care of. And you need to be prepared to do some time in jail. How long, I don't know. And then I'm going to figure out a way for you to get into treatment. I think you need it. You still need it. I mean, I thought we had this licked. This is hurtful.
We did.
That's what we're doing, April 20th at 8:30. Thank you. I'll see you back here. Thank you. Bradley Guy. I want you to communicate with him though, Beth. He's going to come back Monday morning. You meet with Ms. Wiles at 8:15. You guys can put aside whatever differences you have, and we're going to figure out where we can get you in. Bradley Lawrence Guyot, 26B150513A and B. Your name? You're charged with operating while intoxicated, sir. You also have an open intox. You have the right to an attorney. Would you like an attorney?
Yes.
Okay. We'll get you one. You can go out in the hallway and you will meet with the lawyer, and then either way you're coming back in front of me, okay? Stacy. Gerald? Drew Aaron Gerald. 26B150241A and B and C, and I also have two, and that's it. Yes. Oh, I also have Cody Gabriel DeFore. Come on up here. Cody Gabriel DeFore.
You just went to the bathroom.
All right. Your name? You're charged with operating when intoxicated. You're charged with possession of controlled substances. Of a controlled substance, and you're charged with expired plate, and you have the right to a lawyer. Would you like an attorney? Okay, I'm going to go ahead and give you one. You can go out in the hallway. They'll set you up, okay? Thank you. But Russell, Amber Elizabeth Russell. 26B02516.
Good morning, Judge. Nice to meet you, Mr. Russell.
Your name, ma'am?
Amber Elizabeth Russell?
All right, just give me 1 second. Did you guys have a chance to read the victim's rights statement of Emma Russell?
Yes.
Okay. I just wanted to make sure. Is Emma Russell here? Is Emma Russell here? All right. Your client pled guilty to the charge of, actually, she pled no contest, I believe.
Correct.
Under section 771 to the charge of disorderly person. She was referred for a screening and assessment. Have you had a chance to review the report? Whether or not are there any material additions, corrections, or deletions?
Yeah, with regard, we have reviewed the report. It is mostly accurate, except on section on page 2, judge leader drinking and treatment history. it does indicate past use of marijuana. My client indicates that she's never used marijuana or any type of illicit drugs.
Okay, I'll modify the report in that regard. This is quite a telling victim's rights statement. You guys are mother and daughter and you're,
They've been like this with me since I divorced their dad. They moved out. When she moved back and she kept saying, you know, if you want to do this or that, I'll just do it with them. Never to be with them.
okay, but I need to, you pled no contest, so I'm not going to ask any questions about the incident.
Okay.
But that doesn't mean that you can make statements that cause me to think that you're denying any guilt and having to go through with this.
Okay.
Do you understand what I said?
Yes.
Okay.
Yes.
No contest plea, as I told you before, has the same effect as a guilty plea. And when you plead no contest, that still goes down as a conviction. Do you understand that?
Yes.
And there was an agreement to be taken under this statute, and I'll be glad to do that. You don't have anything other than, you have nothing really. So at any rate, that's where I am with it. Anything else, Mr. Gafe?
Just that, you know, Ms. Russell is 44 years old. She's currently unemployed due to some medical conditions. She does have a dislocated shoulder and dislocated ankle. She's currently waiting to have surgery to repair both her shoulder and her ankle, Judge. Afterwards, she does plan on going back to school to get a degree in as an ultrasound tech. Like you mentioned, she doesn't have any established criminal history at all. There was no indication of any type of alcohol or drug use.
Oh, you know, but again, she's denying the probation that she used anything, but then I read here, let me see, what did I see here? The daughter indicated wait a minute. Somewhere in here, the daughter accused her of being high. She said she explained her mother, suspect Amber Russell, who was believed to be high, had been acting strange lately and had been sending odd text messages to family members. So just to be consistent, just so you know, I've seen enough where I'm going to order her to abstain from alcohol, drugs, or otherwise.
No, but I would, that regardless, I think that statement maybe is a little more tailored to what the victim or the alleged victim here said in her recommendation. I mean, she made a recommendation to the court, Judge.
No, this was in the police report.
Well, in her statement, Judge, she did make a recommendation to the court. She did mention what you just said as well. But what she didn't mention was her mother has trouble sleeping. Her mother was on sleeping medication, which caused her to be groggy and slur her speech. Now, aside from the victim's statements here, she's not a certified medical
I get it.
professional.
I get it.
So her assessment of what her mother was on at that time,
Fair.
I would ask the court to give, to take note of that. But again, there's no established, drug history or alcohol history with my client, Judge. She was on medications for her inability to sleep. We do have a med list if the court would want to see what.
No, you know what? I'm just going to order to abstain from alcohol and drugs though still, but I'm not going to order treatment.
Thank you, Judge. That was actually my next point. We would ask that the court reconsider recommendation 5 and 6 with regard to the medical, with the chemical testing as well as the outpatient.
I'm not sure I'm not going to order chemical testing. There's enough here. There's enough here for me to do that. But go ahead. I'm sorry. I interrupted. My apologies.
No. Like I mentioned, the only medications that she's on are prescribed medications. She's currently under the care of a medical professional, and we would ask the court to take that into consideration. That an appropriate finding.
Anything you'd like to say, ma'am?
I'm under psychiatric care. My parents and I are both, all three of us together, are going through treatment together. And then I stopped immediately when I thought it might be that sleeping medication. The very next day I went to the hospital because I wasn't feeling right. And I told the doctor, I was like, maybe it's this kratom stuff that I bought at the gas station because it helped me with my pain. And I didn't want to be on Norco all the time because I saw the surgery coming up. He's like, here's, Bucicone and Suboxone. He's like, take it. It'll help it. Just yeah. He said it'll take away your kratom.
Suboxone?
Kratom, yeah.
We have the med list, Judge. It is prescribed by a doctor. If the court wants to see it. Suboxone, correct, because she was having issues with kratom.
Well, yeah, okay. That makes a lot of sense then. But I mean, it's.
I don't know, because she took that.
It scares me when I start hearing Norco and Suboxone,
And that was the issue, was because she didn't want to get addicted to the Norco and the other pain.
Norco's an opiate.
Right. And I didn't want to keep taking it, in the meantime, in the interim between now and when I had my surgery in May. Because I had 2 surgeries. So I told the doctor, I said, well, what am I supposed to do in the meantime?
All right.
He said, well, not take kratom. And I said, obviously, I didn't know you could get addicted to it. I thought I was doing the right thing by not coming in and trying to seek medications and all that stuff.
Anything else?
Yeah.
No, that's it.
12 months probation. I'll take it under 771.1. I'm going to need a review hearing date in early April or late March, Heather. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any one of those. Kratom, poppy seeds, CBD oils, those are prohibited. Consuming food or other items containing those substances will be deemed a violation. Submit to chemical testing, PBTs, and ETGs monthly or more on demand of probation. Monthly or more on demand of probation. Anger management, you're to attend that with 4-week follow-up. You're to obtain and maintain employment and provide proof. You cannot have, per her request, any contact with the victim, Emma Russell. Pains me to do that when they're.
I would go for the court judge. This is not her permanent address. She was staying with her grandparents. She lives in Lansing. She does have her own residence. She was only staying down here.
Well, I know, but she asked for a no contact, and I'm going to give it to her. No contact with Emma Russell. You cannot write, phone, see, text, email, or communicate with her, or have anybody else do any of those things for you on your behalf. You're not to possess firearms. You're not to possess dangerous weapons. I'm going to require you to only serve 2 days of community service. You're to complete that by June the 1st. You're to pay fines $100. And by the way, again, no firearms. You understand that? No dangerous weapons. $100 fines, 50 costs, 75 victims' rights fee, $50 justice assessment, $275 screening fee, 60 for 335. Probation fees are $240 for 575. I'm not going to order treatment other than the anger. I'm ordering anger management, but I'm not ordering treatment. I don't have enough here to justify that. Yeah. I don't know the situation with these surgeries and Norco, but the doctor's prescribing it. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer. If you violate, your probation could be revoked for 90 days, and you could be incarcerated for 90 days. Do you understand that?
I do understand.
You have like I said, you have 21 days to appeal and 14 days to apply for a court-appointed lawyer. I'm going to give you a review hearing date. If you're compliant, you'll come back. The case would be dismissed. So when are we going to do that, Heather?
April 15th of 27.
Tax day of next year at 8:30 in the morning.
Would the court consider early termination?
That's, these are under the prosecutor's got to move to dismiss. They don't, I'm sure he'll do it. You're going to have to, or she'll do it, I'm sure. But I can't speak for them because they have to move to dismiss that.
And if she does move to dismiss that,
I don't have a problem. No, I don't have a problem with that.
Okay.
Okay, so your review hearing date will be, again, April the 15th of 27 at 8:30. How much of this does she have to pay?
She needs a payment plan, Judge. She's coming out of employment.
Oh, and I did say, I hope I did, maybe I didn't. You're to obtain and maintain employment and provide proof. How much can you afford to pay when, ma'am?
Nothing right now. I'm not working because I've had my surgery. So I'm getting work part-time.
Tell me when you can start paying on this.
I would say probably June, September, series in May.
$50 a week,
Okay.
beginning June. June the 5th, June the 8th. If you don't have the money, you call the court, we'll go on Zoom. And you can ask for an extension. I'll be glad to give you that. If you would rather come in here, just has to be honored before the due date at 8:30 if you come in or when you call, okay?
Okay.
You'll meet with probation.
That's okay.
Good luck. Thanks. Rosanna Martinez, 25B1479378. Okay, where is she at? Rosanna? Oh, I'm sorry. I didn't see you out there. My apologies. Your name, ma'am?
Rosa Martinez.
So this was sent to the prosecutor. Is Donald Cruz here? Donald Cruz is the victim. Donald Cruz is not here. The prosecutor indicated they have no objection, early discharge. Probation says you're compliant. You completed your IOP with aftercare, victims impact panel completed, court work days and community service completed, SoberLink, it says day are completed. I think they just miswrote something there. Balance zero, testing negative. Defendant granted early discharge, ma'am. I wish you well. You're entitled to that by statute, and I'm granting it. We will send you the order from the court, okay? So you're off probation right now, all right?
Okay, thank you.
Best of luck to you. Thank you.
Bye-bye.
Cody Gabriel DeFore, 26B150274. Could I have seated up here Eric Bugaya? All right, you're good there. I'll call you next. Come on up here, sir. This is Corey Gabriel DeFore, 26B150274. Your name?
Cody.
You're charged with possession of a controlled substance. You have the right to a lawyer. It says cocaine on the citation. Would you like to talk? Do you wish to have a lawyer represent you? Okay, we'll set you up with a lawyer. You can go out in the hallway. I'll be right with you. People against Eric Bagaya. He needs a lawyer too. Eric Parenti Bagaya Jr., 26F262289. Good morning, Mr. Counsel.
P7634. Well, yeah, we say the name, sir. Eric Bowen.
So what does this mean? Possible plea?
Judge, there's some other family court matters going on right now that are happening in the next week or so. So we want to kind of see how that plays out before we undertake the plea. We're planning to resolve it.
When?
On the 11th, or on the bench trial date if need be.
Okay. All right. We'll continue to the bench trial. You know, you would help me if you guys know you're resolving this by doing it beforehand.
Oh, I know. As soon as we figure something out.
I got it. You could always get a stip from him if that's what you guys choose to do. And I can, in other words, you guys sign whatever your agreement is, and you can call the court, Heather, give them your extension, will you please? And you can call her and say, when can I get in front of the judge? And I'll do my best to accommodate, okay?
Okay.
But if you decide not to, that's fine. You'll see you at the bench trial.
Sounds good, Judge. So you're aware it's scheduled for 11 a.m. I might be about 5 minutes late. I did.
5-10 minutes. If it's 5-10 minutes, I don't care. If you're showing up at 11:45 and you guys are going to tell me, yeah, we're going to trial.
No.
Okay.
You done with
As long as I know, as long as I have a plea or we're starting a trial by 10 after 11. Lawyers tell me 11 and it's usually 12. And then you guys don't get to get out of here. And that's not fair.
I understand. I just have something at 9:30.
I got it. Good
It's
enough.
taking less than an hour to get here. I just want to make sure that
Good enough. No problem.
there's traffic like today.
Good luck. Go down the hall, get your notices. Have a great day. Be safe out there. Alexis, Rachel, Leanne, Seidler, 26B150604. Your name? Seems like I just saw you. Didn't I just see you?
Yes, this is a different case.
All right. You have the right to a lawyer. This is a 6-pound charge. Would you like one?
No.
You sure?
Mhm.
What were you in here on yesterday? Remind me.
I was in here yesterday for being in my car drunk.
Okay. All right. Maybe you should get a lawyer. Once you get a lawyer, I'll give you a lawyer. Unless you want to represent yourself, like Perry Mason or whatever. You got a drunk driving pending. You got this. I don't know what else you got. Is this your dad?
Yes, that's my dad.
I thought that was him. Get you an attorney. Go out and get an attorney, and then you can talk to him or her, and they'll help you. Benson. Nicholas Allen Benson, 25B147801A, B, and C.
Good morning, Judge. Matthew Gates, Mr. Benson.
Mr. Benson, your name.
Nicholas Allen Benson, Your Honor.
I ordered a pre-sentence report. I don't know why I did that. It was a drive while suspend, no insurance, and resistant obstructing officer. I know I did that in part. Wait a minute, what do you, hang on.
Oh, I'm sorry.
Yeah, just let me, I gotta put some things on the record here. So I ordered a pre-sentence report and, they're not fooling around over there, are they?
No.
They're recommending jail.
No.
So, you had a chance to review the report?
Yeah,
Any material additions, corrections, or deletions?
it's actually.
Anything you'd like to say? He's got, so just let me go back here. He owes money on file 801C. He has not been sentenced on the suspend charge yet. He's not been sentenced on the charge which caused me to refer him, and that was the R&O that was reduced to disorderly. You know how bad your record is.
Yes, sir. Say some.
No, let me know.
Go ahead.
Yeah, we haven't had a chance to read the report. On behalf of Mr. Benson, Judge, he is 45 years old. He is currently unemployed due to the fact that he was diagnosed with multiple sclerosis. He's applying for SSI, Judge. He was just recently released from Wayne County Jail where he did a year on retail fraud. He was released in February of 26.
If there's a two sentences,
Let him finish.
He currently lives with his mother, who's 83 years old, Judge, who suffers from dementia. He is her sole caregiver. There was a living nurse who was helping her out. That nurse was found to be committing all sorts of larceny and embezzling certain financial assets from the mother.
1 second, John. You took his daughter's case to the lawyers, right?
It's-
I'm what I wanted to say, she got away on it. Oh,
Right outside. I just thought you went down the hall. What was her name? What's your daughter's?
I have that file.
Thank you. Sir, just please, she's to wait out there for this lawyer. Go ahead.
Judge, and to Mr. Benson's credit, Judge, he was the one that, he tried several times to do a plea by mail while he was incarcerated. That never materialized.
Hang on, let me see. Wait a minute. Let me double check. I'd be shocked if I didn't respond. Did I respond to you?
He said he also submitted an apology letter.
With an apology letter, but at the time, the R&O.
Hang on. I mean, I'd be shocked if I didn't respond.
Then back in.
Listen, I got it. Just give me a second, will you please?
Yes, sir. I apologize. Yes, sir.
I never received the plea by mail request on this. Never. Wait, maybe it was put in the other file. Give me 1 second. I'll double check. Maybe it was put in this suspend charge. As of April 10, you still got a warrant out of 35th District Court?
He's in the process of taking care of it. He does have court dates already scheduled.
Okay. You did send one July 75, July 7 of 25, I should say. Let me see something here. Glad that, I mean, it's my practice to respond to these, and I don't see where I did. Go ahead.
Yep, so when he didn't get any response to those, he did walk in on his own volition, Judge. And
When was he released?
he was released in February of 26, correct?
I was released from Oakland County in November. I came to court that turned myself in, came to court, got a personal bond and was ahead of court date scheduled, but then I had to go back to
Wait a minute,
Wayne County on another charge.
wait a minute.
I was out for,
You came in here November 12th to 25.
right, and then I had a court date for the second, I believe, of December, and I missed that because I got incarcerated by Wayne County for another case. And then I did the time in Wayne County, and when I got out of Wayne County, I reported again to Brownstown again. The only reason I missed court date was due to incarceration.
Gosh.
I know it's been I made a mess. A couple years ago, I made a huge mess in my life. I'm cleaning it up right now. I'm facing it head on.
How old are you?
I'm 45. Clean and sober now.
Wow.
So I'm on felony probation for the Wayne County case. But I'm trying to clear all these things up. I made a huge mess.
All right, okay, slow down. Are you done talking?
Judge, I would just ask the court to take that into consideration, that he's in fact trying to clear up his past issues and anything that's outstanding. And the fact that he is caring for his elderly mother, along with his current medical situation, Judge, I would ask the court to sentence him to probation. And he's assured me that he would do whatever it takes to comply fully and put these issues behind him, Judge.
Anything you'd like to say, Mr. Benson?
Just, I stand before you, a humble man, Your Honor. Like I said, I made a mess in my life in communities. A couple of years ago, I was committing retail frauds and I was on drugs. Since I've been released from Wayne County Jail a couple months ago, I've made 2 truthful reports to my felony probation, which has been clean drug tests, and I'm attending team wellness, which I'm seeing bi-weekly. I see a therapist. I also am seeing a psychiatrist, and I'm back on my medication. I know I have a slew of court dates, a slew of capable cases that mounted up, stacked up on me. I'm facing, I got Van Buren, I got Huron Township.
What judge are you in front of on the flee and elude? Were you sentenced on this?
Exactly, I was sentenced. That's what my felony, I was sentenced to jail time and then
how much
the follow.
How much?
I did 90 days in jail on that case, but 8 months in Oakland County and retail frauds prior to that. They were back to back. Like I said, I'm being sober now, and I'm ready to face on, take on probation, community service, whatever. It keeps me busy anyway, doing all that stuff, and that's good for me. Just give me a shot. I know the PSI. My record's horrible, and the PSI recommends jail time. I understand it, but if you let me give me a shot at probation here or whatever I need to do, I promise I won't lay it down. I'm like I said, I'm a humble man standing in front of you. One more thing, if I may, Your Honor. In your defense, the mail ran really horrible in Oakland County Jail. My mother sent me several letters that I never received. So you may have responded to that plea back in July.
I don't see where I did.
So I
don't see where I did, and that's unlike me. I don't know why that would have happened. I got to be honest with you. I don't know why that happened. I don't just throw these in a drawer somewhere, and I don't see where I did. And that's going to benefit you here today. Here's what I'm doing. I'm giving you credit for time served on the no proof insurance. You're giving credit for time served in Oakland and Wayne County jails. So I'm going to go ahead and just get rid of that. And then on the other files, I'm going to go ahead and assess on both of them. I'm going to go kind of light on fines. 100 fines, 100 costs, 75 victims' rights, $50 justice assessment, 3 1/4 on each file. 3 1/4 on each file. I'm about to suspend I'm gonna give you 30 days, credit 30 from the Oakland County, and Wayne County time that you served. It sounds like, so, and then I'm gonna give you 60 more days if you don't pay your fines and costs. They're 3 1/4.
Thank you.
Each case,
Is that 650 total?
650 total. So here's what I'm gonna let them do. I'm gonna let you pay $50 per month. Heather, I don't care how you do it. Print out 50 a month. You can pay them back to back. I don't care if you put it on the A file first or the B file first. So you can pay 50 a month. If you don't have the money, you call the court, we'll go on Zoom, or you can walk up here or drive up here, I should say. You live in Flat Rock. You can't drive up. You don't have a valid license, but you get what I'm saying.
Yes, sir.
So you set up the payment. I don't care where it starts, 50 a month on the 1478001A and 1478001B. And I'm going to close out the no insurance. You still have to pay the clearance fee on that, okay, to get your license back. That's $45. I don't know about the rest of your issues. And you need to go over to those other courts and take care of those, okay?
And what was the start date for the payment plan?
I'm going to let Heather set it up.
Okay.
Did I not say May?
No,
Didn't I say anything? My fault. When do you think you can start? June 1st?
Can I get to July 1st?
July 1st.
So are they going to send a notice in the mail too?
No, for what?
I just wonder because they have the wrong address if they are.
Well, you go down and tell my judicial clerk what address you live at.
We will give him the payment plan up here also, Judge.
Whatever you set up is fine with me, Heather. Go talk to my judicial clerk. She'll be great with you. Okay?
Thank you, Ron.
Stay out of here. I hope you're changing your life. Good luck. Chandler. Nicholas Elijah Chandler, 26B150526A and B. Can I have seated up here Kirk, Leah Kirk, seated at the table. Mr. Chandler, come on up here and tell me your name. Ma'am, you can come check in with my court officer. When I call your name, sir?
Nicholas Elijah Chandler.
You're charged with driving on a suspended. You have the right to an attorney. Would you like one?
No.
I'll go ahead and arraign you and I'll let you talk to the prosecutor then, okay? Fair? Fair enough?
Yeah.
All right. Brownstown Township thinks you were operating a motor vehicle there on March 29 to 26 at 1:30 p.m. on Inkster near Claret in Brownstown. They think you had a suspended license. That is a misdemeanor punishable. That the 500 fines, 93 days jail costs are all those 2 points. They also think you were speeding, going 1 to 5 over. That is a 1 civil infraction. You would only get the higher of the 2 point totals if you were convicted both. Do you understand that?
Yes, sir.
Did you sign, read, and understand the advice of rights?
Yes, sir.
If you plead guilty, you'll be giving up all those rights, and we're not going to have a trial of any kind. Do you understand that?
Yes, sir.
All right. You still wish to waive your right to a lawyer?
No.
You want a lawyer now?
No.
Who's this?
My girlfriend.
Do you want a lawyer? If you do, that's fine. Talk to me. Come on, talk to me.
Yeah.
All right. I'm going to enter a not guilty plea, $500 personal bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. We'll give you a lawyer. You go out and talk to the lawyer. And then the lawyer will talk to the prosecutor any way you're coming back in front of me. Okay? Good luck. Leah Marie Kirk. Leah Marie Kirk, 26F245713, A and B.
She's
Leah,
on Zoom.
Okay. Ms. Kirk, you have to start your video, ma'am. Good morning.
Hello.
Tell me your name, please.
Leah Kirk.
You're charged with disorderly conduct, public intoxication, and also resisting obstructing an officer. You have the right to a lawyer. Would you like one?
Yes, please.
Okay, we'll give you a lawyer. Just be patient. They're busy.
Okay.
And we'll go from there, okay? So
Okay.
just be patient. Thank you.
No worries.
Who's this gentleman in the green top there? I can't read.
I do not know. I keep chatting to him and he's not giving me his name.
What? Ma'am, they're going to put you in a breakout room.
Yep.
Sir.
Just join that.
It looks like you're spelling something. I don't know what language that is. What is your name in the green top? You. What is your name, sir? Yeah, your name. What is your name? Can you spell your last name for me, please?
What? What? It sounds like he has somebody speaking on a phone also with him.
K-U-B-A-T-N.
Judge, it is at 10:30. It's Cuba. I can't even say the last name.
I don't think I'm going to be able to communicate. Do you speak English, sir?
Yes.
All right. Who's talking to you in the background there?
Hey.
There's somebody else talking in the back. Who is it?
Son.
Who's that guy?
Son.
I don't know who the guy is talking. Who is it? He has no business being here. Where's this guy from?
My son, My son, yeah.
Well, your
He's
son
got
can't
CMV charges.
Say that again, Heather.
It's for him, but like he just said, I believe his son's speaking in the background. He's here on an arraignment for CMV charges, it looks like.
Yeah, where's the office at? Where do they have them? I'm going to find this impossible unless, I'll try to roll through it if they live in Kentucky or Texas.
Let me
if he lives around here, I want him to come in person. I'm having a hard time doing this.
New York.
Okay, let me talk to your son a second. Sir, the gentleman in the background there, is your son with you, sir?
Hey, no good, listen. Hey.
Who's the gentleman that was talking for you? Where is he?
Yes, pretty English.
I can't hear you. I can't understand you. Yeah, but there's a guy in the background that was talking. What language do you speak?
My son, Atay Bek Akishev. Atay Akishev.
He's saying his name again.
He joined us.
I know. I don't know what kind of.
Yeah.
Which one joins him?
Where's your son at?
Oh, wait. Yeah, I'm bringing him in right now. I think he might be coming in on Zoom too.
Okay, good.
His son. There's his son.
1 second, sir. Okay, just give me 1 second. Do we have that file of Thai ad there? Or is it in here?
Yes, sir. Good morning.
Give me 1 second, sir. I need that file, you guys. Just stay right there for me. Well, yeah, I'm going to try to help you out here, okay?
Thank you so much.
It should be in our arraignment pile in there.
I'm going to call this Kubitbek Akashev, 261-507-518 B and C. All right, Mr. Atay Akashev, what's your name?
How you doing, Mr. Judge? My name is Ataybek Akishev. I'm a son of Kubatbek Akishev.
What language does your father speak?
He speaks Russian.
Russian?
Yes. He speaks English too, but he's having a hard time to listen because he's in the truck and just pulled over something in the truck stop.
But you got to help me out.
Sure.
I'm going to get him a Russian interpreter.
Sure.
I'm going to reschedule this. But he can't be in a truck next time. He's going to have to be in a place where I've got a good connection. Will you convey that to him, please?
Yes, sir. I was really trying.
I'm not going to make him come here. It looks like he lives in New York.
Yes.
But he's got to be in a place where I'm going to be able to talk to him on Zoom. So, in fact, who's Sherilyn Foster Tucker? Who's that?
Sherilyn Foster Tucker. We don't know.
Lawyer entered an appearance on this.
Yes, I am seeing that. Did he hire? I do have a.
Did your father hire a lawyer?
Oh, yes. I forgot the name. I apologize.
Where is the lawyer?
Not on Zoom.
They should be here. They send us the email from Stephanie, Sam, Charlene to appear in the Zoom, and they were telling us they will be representing my dad, but for some reason they're not here today.
Gonna track down lawyers. Will you talk to that lawyer and make sure the lawyer's here? Tell your father I'm adjourning the arraignment and pretrial today. We're gonna adjourn the arraignment and pretrial. The lawyer needs to be here. I'm rescheduling this. Give me a date in 2 weeks. We doing the 30th?
Yes, at 10:30.
At 10:30. So
Okay.
the lawyer, Mr. Akashev, needs to be here. We are going to get a Russian interpreter here, but the lawyer needs to be here. Will you convey that to her, please, sir?
Yes, I will.
April 30th, write that down for me. 10:30 in the morning. Make sure your dad is in a place where I can talk to him on Zoom. He shouldn't be in a truck. He's
Sure,
going to have to be somewhere else. I mean, I don't mind if they're in a truck, usually if it's not moving,
Mm-hmm.
but there's a language barrier here and he's going to need to, it's going to be hard enough. Okay? Thank you.
Okay, sir. Thank you so much.
Natalie Nicole Brown, 260-245-755 A and B. Entering without authority and destruction of property. Come on up here, ma'am. Your name?
Yeah.
Do you want a lawyer? I can't hear you.
Yes.
Okay, we'll set you up with an attorney. You can go out in the hallway. Okay, thank you. Mazzolini. Gustavo Ruben Mazzolini, I think. 260-265-709, 260-265-769. Your name, sir?
Masolani,
Did you have a lawyer?
I did, probably.
I can't hear you.
Theo.
Okay, so I'm not doing no contest on these. No. Where's Miss Patillo at?
She's in a breakout room right now with
Have a seat at the table there, sir. Right there. I need to take 5 minutes too. Everybody stay seated. I'll be back in 5 minutes. Thank you.
Dion Patillo, PA 2378, on behalf of Gustavo Mazzolini, Section.
Gustavo Masolani.
We got 2 window peeping cases. Why am I doing no contest? Because he doesn't want to.
Liability.
Nah. No, I'm not doing that. I'm sorry.
It was mainly because of the explanation.
What do you mean the explanation? If he can't establish a factual basis, then we'll just set it for trial.
He can, but it's just for services. It wasn't what it actually is, if that makes sense.
And it doesn't make sense.
I know, Judge, but it,
What time is this at?
one was in the morning, one was at night.
Hang on. 10:05 p.m.
For a reason, Judge.
Well, you're going to have to tell me. I mean, if it's just a matter of somebody not wanting to admit that they're guilty, that really isn't an appropriate means to go about it. Is just doing it as a no contest plea. Hang on. If the plea no contest is because he can't make out a factual basis, that's not appropriate either.
That's not the reason, Judge. It's, I can't really say on the record, because I think it was an attorney-client privilege. But it was just for a specific reason.
Specific reason. That means somebody's going and looking through windows late at night. And stranger. I don't know what to tell you. I don't feel comfortable with a no contest plea. For the two reasons I mentioned, it's either there's no factual basis, or I'm not buying the possibility of civil litigation. You got two different dates, two different victims, it looks like.
I think the dates are the same, it's just two different times. I think both in March 31st, 2026.
You could be right about that. Yes, they are. Different times, different locations a little bit. I think they were both, let me just double check. Yeah. Look, I'm having a hard time with this no contest plea, Mr. Cayley. Your name? Your name?
Robert Taylor.
I'm having a hard time with that. I think I want us to regroup. I don't have time to do it right now. We got a lot of people. I'm going to reschedule this, okay?
What's the charge, Judge?
The window peeping.
Oh, okay.
You and I and Theo will sit down next time. We'll make it April 30th, okay?
Okay.
April 30th at what time, Heather?
10 o'clock.
10 o'clock. Okay, sir. You come back then and we'll see you back here. So go down the hall, get your new notice. Your trial date will be April the 30th. At 10 o'clock, okay? All right. Good luck. Thank you.
Thank you, Judge.
Getting a little backed up here, so let me, Jarrell, come on up here. Did you have a lawyer?
Yeah.
Okay, people against Drew, Aaron, Jarrell, Junior, 260-150-241A and B and C. Your name? And counsel, your appearance?
Peter Granada, P78413, MIDC counsel for Mr. Jarrell.
Good morning to you, Mr. Granada. So we've got an operating while intoxicated. We've got possession of a controlled substance, possession of a controlled substance, and an expired plate charge. So first of all, in the misdemeanors, does he in fact stand mute and waive formal reading of the citation?
Yes, Your Honor.
All right, so I'm entering a not guilty plea for you for purposes of arraignment on the OWI and possession of a controlled substance. Now, as I understand it, there is going to be a plea of guilty to the charge of operating while visibly impaired, at which time the OWI will be dismissed, and he's going to plead guilty as charged under Section 7411 to the possession of a controlled substance charge. True?
Yes, Your Honor.
He's never had one of those.
No.
He's never had a drug offense before.
No, Your Honor.
So, sir, if you plead guilty, did he sign an advice of rights form today?
It should be in the folder, Your Honor.
I see it. So let's start over. If you plead guilty to operating while impaired, I'll dismiss the OWI with the further understanding that you plead guilty to possession of controlled substance under Section 7411. Once you do that, I'm dismissing the OWI and expired plate. Do you understand that?
Yes.
Operating while impaired carries the possible penalties, the following possible penalties: up to $300 in fines, 93 days jail. Court costs are all those, 360 hours community service, 4 points on your license. Your license will be suspended or revoked in accordance with your record. Do you understand that?
Yes, Your Honor.
Possession of a controlled substance carries with it fines of up to 590 days jail. Costs are all of those, but I'll defer to proceeding. I'll take the plea, send you for a pre-sentence report, set terms and conditions. If you're compliant at the end of this period that I set, the case will be dismissed. Do you understand? When you plead guilty to those two, I'm going to dismiss the OWI and expired plate. Do you understand that? Did you sign, read, and understand the advice of rights form?
Yes.
If you plead guilty, you'll be giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that?
Yes.
With the charge operating while visibly impaired, how do you plead?
Guilty.
To the charge possession of a controlled substance, how do you plead?
Guilty.
On March 15 and 26, were you operating a motor vehicle on Rochelle near Relda in Brownstown at 6:01 p.m.?
Yes.
Prior to that, did you drink alcohol? And if so, what did you drink and how much did you drink?
Yes, I had a few beers downtown for the parade. Probably 8 or 9 beers throughout the day.
Was your ability to operate the motor vehicle impaired due to the consumption of the alcohol?
Yes.
How much did you have to drink?
It was a day long event, so probably about 8 to 9.
And when you were pulled over, did you have a controlled substance in
Yes.
possession, in your possession?
Yes.
What did you have?
Okay.
And where was that located?
It was in my pocket.
And that was yours, correct?
Yes.
Are you on probation or parole?
No.
Anybody force you to plead guilty?
No.
All right, I'm going to accept your guilty plea to operating while visibly impaired. I find it to be an accurate plea. I'm going to accept your plea of guilty to possession of a controlled substance. I'll take that under section 7411. Section 333.7411. So that means, again, I'm deferring that, and I'm going to go back and I'm going to dismiss on their motion the expired plate. So the OWI is dismissed, plate charge is dismissed, and again, please accept the operating while impaired, possession of a controlled substance. I'm referring you for a screening and assessment. You're going to fill out a questionnaire and be interviewed. Today, you'll come back for sentencing at a later time. Does he have any prior alcohol-related convictions, counsel?
No, Your Honor, nothing wrong.
Any prior convictions of any kind? Well, you got to resist and obstruct, drunk and disorderly. You had a felony armed robbery, right?
Yeah, it's 917.
Yeah, I know, but still. I want you going to AANA at least 3 times a week. So I'll give you a personal bond, $1,000. But here are your bond conditions. You cannot leave the state with
Good morning, Your Honor. Assistant Public Defender Don, leave on behalf of Mr. Gobb. Gobb, can you tell the judge your name, sir?
Russell roll. And Your Honor, I'd like to set this matter for preliminary examination, please. Discovery is complete.
Discovery is complete.
Yes, Your Honor.
People have their witnesses available the 28th.
You can track that they are.
All right. Preliminary examination will be set April 28th, 2026, 9 a.m. before Judge Barr.
Thank you.
Bond will continue. Thank you. Court does call the case of the people versus Melinda Baker.
Michael Gaddy, Assistant Public Defender on behalf of Ms. Baker, Your Honor. He is here by Zoom.
Oh, there she is. Ms. Baker, can you state your name, please?
Melinda Baker.
Thank you.
Your Honor, may we approach very briefly?
Yes. Yes.
Where are they approaching? I don't like it.
It is not, Your Honor. We're still waiting on receiving some body camera. Harvey's indicated to me that he would not like to waive any time frames and would like to set this matter.
All right, but he understands also that if that does not appear, it's not going to be the basis for an adjournment.
He does understand that I did review those, Mr. Harvey.
We'll have their witnesses available on the 28th.
Can you reach out to the sheriff's department about the body camera? I agree that, but I need to do a little bit more discussion.
Preliminary examination will be set April 28th, 2026, 9 a.m. That's before me.
Thank you, Your Honor.
Esteban.
Mentioned that the party has contacted a number that the victim is using 16 times, and how we know it's the number for the victim is she's referred to as his wife. He loves her, begging for her forgiveness. So at this point, I'm going to be asking for his calls and texts to be revoked. He talks about what might happen with the case, if they come to court, if they don't come to court. So at this point, we'll ask for his calls and texts to be revoked.
Any response?
No, Your Honor, this is my first time hearing about this. It's not too far.
Well, we'll get that to him. And at this point, I'm going to revoke the defendant's phone and texting privileges from the Washington County Jail. Right. Thank you. Court calls the case People versus Shelby Barber.
People, Your Honor.
Brother Judge, court shall cease to Assistant Public Defender on behalf of Shelby Barber. Please
Your
take.
name?
Shelby Barber.
Thank you.
Well, thank you, Judge. According to our notes in the file, it looks like we are missing a second police report in this file. And so we're going to be requesting an adjournment so that we can get that second police report.
You know anything about that?
Yeah, Your Honor, my understanding is that the report is included in the media notice on this file, but I can route it different way.
It's a different.
Thank
Okay.
you so much. Appreciate it. Thank you.
All right. I will adjourn May 7th, 2026, 9 a.m.
Thank you, Your Honor.
All right.
Thank you, Judge. Be in touch.
Court calls case People versus Larry Passaru.
Brian Bowling on behalf of Mr. Tassaru, Your Honor. Can you state your name for the record, please?
Larry Tassaru.
Your Honor, I'm asking for a preliminary examination in this matter. I believe all discovery to be complete.
All right. People have their witnesses available on 28th.
Well, Your Honor, there is one uncharged case, which I think would be a misdemeanor that's slightly related to this. So I'll work on getting that police report disclosed to defense before that date, just so they have absolutely everything. But I think as far as the four corners of this case, we do have everything disclosed. There's just one more thing I'll get over there. Right.
All right.
That is my understanding. Thanks, Judge.
Preliminary examination, April 28th, 2026, 9 a.m. That's before Judge Barr.
Thank you, Your Honor.
Thank The court calls the case People versus Manuel Brandt House.
Here, Your Honor.
Stephanie Hanna on behalf of Mr. Brandt House, who is appearing by Zoom for Barnt House. Mr. Barnt House, could you please state your name for the record?
Manuel Barnhouse.
Your Honor, we're just asking that this be set for a preliminary exam.
The
Oh, and we also have to arraign him on the additional charge.
yes, on the additional charges counts 4 through 7. Have you gone through that with him?
Your Honor, I have emailed him the information and we discussed it. Yes.
All right. And so as to the arraignment on counts 4 through 7.
Your Honor, my client would stand mute and ask for his next court hearing.
All right.
And we would waive the formal reading.
Defendant standing mute, or waiving formal reading, standing mute. Court will enter a not guilty plea as counts 4 through. I will want to set for preliminary,
Yes, Your Honor.
right? Would you be ready to go with those amended counts on the 28th?
Your Honor, it's my understanding that paperwork, yes, they've already given me what they have regarding, and I'm not anticipating any additional discovery.
Your Honor, based on the nature of the new offenses, should counsel wish to review those prior to the examination, we would need to set up a meeting with officers. That's taking place. So I don't know if that's necessarily.
So that doesn't sound like discovery is complete.
Your Honor,
Wants to do that sometimes. Doesn't want to do that.
I was provided with a packet of the download from your other counsel. If additional discovery has been created, please let me know.
And based upon the offenses.
Then yes, Your Honor.
Yes, Your Honor, what?
Yes, Your Honor, we'll ask for another PCC date.
That's probably wise. All right. Probable cause conference will be adjourned to May 7th, 2026. 9 a.m. Bond will continue. Thank you, sir.
Thank you, Your Honor.
Cannon, you really are having problems without a. No, you don't have to explain.
I did ask the other attorney if there was anything in addition to what he had provided me. He said no, but I'm getting
What?
information from Mr. So that's fine.
Who said no?
We'll work it out amongst ourselves.
Who said no? Well, you're just ignoring me now. You're not even talking to me. I'm not here to embarrass you. I will, but I'm not. You know what? She's not even paying attention, not even paying attention. Not even, fine. No, you're not. I'm done with you. Courthouse case, Drew versus Cameron Larry.
Then we have.
Well, Senator Donovan leave on behalf of Mr. Larry. Mr. Larry, can you tell the judge your name, sir? Cameron Larry. And Your Honor, I do have a green sheet. I'd like to request an adjournment in order to just receive some additional discovery.
Any objection?
Your Honor, the additional discovery is new jail calls.
That's correct.
New jail calls from him to,
Last. From other pins.
did I already revoke his privileges? So he just went around my order? Is that right, counsel?
Your Honor, based on what I've been informed by Ms. Zenda, that would appear to be the case. However, I have no direct information.
I think I'm on more. So you have information after I revoked his privileges that he was contacting the victim in this case, Ms. Zenda?
Yes, Your Honor.
All right, bonds revoked. I'll grant the adjournment to the 7th of May, 9 a.m. Thank you.
Thank you.
Court calls case People versus Ronald Banks.
Fellas to the people.
Assistant Public Defender Chelsea Vergils with and on behalf of Ronald Bay. Please state your name.
Ronald Bay Jr.
Thank you, sir.
Your Honor, we're asking for a, sorry, preliminary exam in this case.
All right. Discovery is complete.
Yes, Your Honor.
People have their witnesses available the 28th.
We'll try for that date, Your Honor.
All right. Preliminary examination, April 28th, 2026, 9 a.m. That's before me. Okay. Thank you.
Thank you, Your Honor.
Great.
Let's see, Your Honor.
The court calls the case, people versus Terrence Smith.
Assistant Public Defender Chelsea Vergils with and on behalf of Terrence Smith. Please state your.
Terrence Smith, thank you. All right, what are we doing?
Your Honor, regarding the probable cause conference, we need to ask to adjourn. I understand Mr. Smith wants a preliminary exam, but we haven't received any discovery yet.
You don't have the discovery to be able to go ahead
That's correct.
or advise. Is that coming anytime soon or do we know?
And the video I just sent this morning. Or last night, maybe when I talked to or Jess, I can't remember. The original discovery, it looks like it went over on the 10th. So I think they're trying to track that down.
Tracked it down. You want 2 weeks to do that because you got to go through it with him.
Yes, please.
All right. Probable cause conference then will be adjourned to April 30th, 2026, 9 a.m.
Have the date.
Bond continue. Okay.
Oh,
go ahead.
Like to address bond. Does the court
Go ahead.
the bond violation today?
I would, but actually he's being held without bond at this point because of violation of the exclusion zone. So if you want to address it, we can address it.
Your Honor, my understanding was that he was on a GPS tether on this case as well. If that is the case, we would ask to address bond at this time.
That he was on one? Yeah,
I
he
had,
was on one.
yes, I had a bit of confusion about that because this is just an R&O, not a DV, but Mrs. Feltis informed me this morning that there was a tether on this case too. I mean, I just don't want to postpone anything unnecessarily.
Well, I don't want to postpone anything unnecessarily, but there was an exclusion zone, from my understanding, that he entered. Right.
Your Honor, he would admit to entering the exclusion zone, and I would ask to address bond.
Go ahead.
You know, my understanding, based on my conversations with Mr. Smith, I was.
That usually happens when somebody's about not to tell me the truth. Go ahead, Ms. Virginia.
Your Honor, so my understanding on what occurred in this case is that he did go in the exclusion zone. He admitted that. So he was with his cousin. He's having trouble finding work. His cousin offered him work. And he got in the car with his cousin, didn't know exactly where they were going. They entered the exclusion zone. His tether went off. They immediately left the exclusion zone. And Mr. Smith then called his tether agent. That's my understanding. I don't believe he was there for any prolonged period of time. And I understand he's being held on other cases. He hopes to be released on those cases. So I am asking the court for a personal bond.
I don't have any indication as to how long he was in there. I also don't have an indication in this that he called his agent.
I understand those details are not in the report. I haven't been able to get in touch with him, but I'm asking the court to take Mr. Smith's word for it. I don't believe that there was any contact, which is something that is included in the report.
Well, I might do that, except that usually if like the contacts like that occur or those kinds of things, that's specifically included in the report as to how proceed to take somebody into custody.
I don't believe he was taken into custody while he was in the exclusion zone. Yes, Mr. Smith?
Can I say something?
Yep.
4/23, he was taken into custody on the 13th.
I was taken in custody at home because I called my the GPS monitor dude, and then when I asked him, I was like, my tether just went off. My cousin had came and got me to help him move. And when I called him, he's like, he can't get no ping. And he said the police are outside. He's like, yeah.
I thought you were looking for work.
Yeah, I was looking for work. My cousin had offered me some money, but I couldn't. When I got there to the zone, when he pulled up, I'm like, cuz I can't be right here. So as soon as I pulled up, I had to leave. I couldn't even get the money. But I called the community corrections and I called my GPS monitor people. I called them.
Mr. Levitt, correct?
Yes, Brian Lever, and I called the GPS monitor people and I admitted to being right there. I'll take full accountability, sir.
At this time, and until some of that can be verified, his bond is revoked because he entered the zone. I'm going to leave it at revoked at this point. If indeed get through to his GPS monitoring dude, then you can figure out from that person whether or not what he's saying, and I can get some verification of that. I'll certainly consider it.
I will work on that, Your Honor. Thank you.
Thank you.
I'll work.
Court does call the case, People versus LaShawn Charles.
I should spell this for the people.
And Assistant Public Defender Jay Bellinger on behalf of Ms. Charles, who appears via Zoom. Ms. Charles, can you please state your name for the record?
Sean Charles.
Thank you, ma'am.
Your
You're
Honor,
welcome.
at this point, I'm just seeking a couple more weeks. I have reached out to Ms. Burton Harris several times. I'm just waiting to hear back from her in terms of an offer on this case.
Got it. Court for its part also does not believe that there's conflict either under Michigan court rules or the case is decided. The extent of conflict does exist given the
Weeks. I have not worked with this.
Your Honor, at this time, the people are going to be objecting this is the case. Was strangled by the defendant to the point of unconsciousness and wants to make sure the defendant were all pleaded to the very lengthy history of domestic violence, including a DV conviction in 2010, 2 FA expired in 2015, a DV conviction in 2019, and ongoing aggravated DV complaint was for the 2023 domestic violence conviction, along with the dismissed DV third cover 2025. So at this point, I'm as to the phone privileges, I don't recall that being revoked. I don't believe that was expressed at arraignment. So
I don't see that I ordered it, so I don't.
Right. my client says it's from a previous incident case that it was convicted, but if it is, then I guess a stipulated order from the court.
I'm not stipulating any. I don't know why they're revoked. It may be proper that they are revoked because I had contact the victim. So I'm not going to agree to anything regarding that. You can talk to the prosecutor about that. And
All right.
With it, but I'm not agreeing. I want to make it clear. I'm not agreeing to restore anything.
Sure.
Motion for bond reductions denied. Bond will continue.
Thank you, Your Honor. Bond reduction denied.
Court calls case People versus Robert Laster.
Ashley Feltus for the people.
Kyle Burdell, excuse me, Kyle Burdell on behalf of Mr. Laster, who's approaching the podium.
Michael Gaddy on behalf of this Laster in 23 FT 1486 and 1117 just.
Just attorney and a bond argument request.
How you doing, Justin? Your name?
Robert Laster, just.
Doing.
Your Honor, on my case, at least, it's my understanding, based on what's in Mr. Gaddy's hand, we are both asking for adjournment at this time. I do have a bond request from the court. Would like to hear it.
That's correct, Your Honor. I think it'd be prudent to keep all three together.
May 7th, 2026, 9 a.m. Esteban.
Your Honor, Mr. Laster.
May I approach, Judge?
Okay. Okay. Sorry, approach. Oh, is it just a hand in the
Just a hand in the.
Oh, sure. Your Honor, as to the bond request, so Mr. Laster lives in Mississippi. He's currently basically couch crashing with a friend. And so his bond has already been modified from community corrections, or his community corrections already has instructions to allow him to test locally where he's at. But at this point, it's my understanding that he does not have permission to leave the state. So we just ask that he be allowed to return to his family. He has a 10-year-old daughter and an 8-year-old grandson back home in Mississippi that he needs to get home back to and take care of.
The first thing, though, is that he corrected the community corrections violations.
That is correct, Your Honor. He went and tested this morning. I spoke to him yesterday. I went and spoke to him yesterday. He called yesterday before duty, then immediately after I informed him of the issue.
And I'll echo the same as Mr. Gaddy. He was very apologetic and Mr. Laster was very apologetic and eager to correct his mishap and his oversight.
Response from the people.
Your Simpson has gotten he did his initial test. I don't know if we have those results yet. If it was just this morning, that would be something I might be interested in.
Before any agreement.
Yeah, just because there was that bond violation, not going to test for almost a week. Maybe a week, actually, now that I think about it, it was money.
Motion for bond modification. All right, bond will continue as it's AC can't leave the city.
Understood.
Thank you.
State your office.
7.
Thank you.
Oh.
Thank you, Your Honor. Thank you, Your Honor.
Court calls the case People versus Tanisha Moore.
People, Your Honor.
Perfect. Kyle Burdell standing in for attorney of record Bill Amadeo on behalf of Miss Moore.
Your name?
Tanisha Moore.
Discussion to Mr. Burdell stepping in.
Stand in on behalf of Mr. Amadeo today.
Oh, cool.
Is that all right?
That's true.
No? All right.
No objections. Thank you. So, Your Honor, at this point, it's my understanding that the parties are working on a resolution. I have the green sheet for your deputy.
Probable cause conference will be adjourned without objection to April 30th, 2026.
Thank you, Judge.
Continue.
Bill will be in much.
Okay, thank you.
Thank you.
Court does call the case People versus Lewis McSwain.
Ashley Feltus for the people.
Kyle Burdell on behalf of Swain, standing in for attorney of record Bill Amadeo.
Be here.
I don't believe he is, Judge, unless he's on Zoom. Mr. Amadeo has been attempting to contact him, but I cannot explain his absence here today.
Swain. bench warrant will issue for defendant's failure to bond is set in the amount of $10,000 cash shirt. Will issue immediately.
Understood. Thank you, Judge.
Court does call the case for People versus Walter Rice.
Your Honor.
Opinion.
He's Oxford. Three on from the bottom.
All right. Counsel for defense state their appearance. We don't have him here anyway, right? Pass this matter.
I'm sorry, I'm here. I'm filling in for Attorney Max Dubin.
Do you know where your client is? We
Yes,
don't.
he's at in custody.
Okay.
And I did not see them on Zoom.
You're right, but he's not here. We don't know where he is. Is that right? Ms. Mullhern?
Yes, that is correct.
He is in custody in Macomb County Jail.
Oh, well, that explains it. He's not in custody here. He's in
Correct.
Macomb.
Yes, so he should be on Zoom.
No, because I don't think the writ was done. No writ was done because we did not know that he was located in Macomb County.
Okay.
So I will adjourn the probable cause hearing. Do you know how long he's intending on being in Macomb?
I do not.
I'll adjourn the probable cause hearing to the 30th, so the writ can be prepared, and then we'll proceed from there.
Thank you so much, Judge.
2026, 9 a.m. bond continued.
Thank you, Judge.
Thank you. Court calls the case People versus Justin Chavez.
Yes, Your Honor.
The AG's. Oh, there she is.
Good morning, Your Honor.
Good morning. State your appearance, please.
Carrie Angie on behalf of the Attorney General's office.
Thank you.
And Stephanie Canna on behalf of Mr. Chavez. And I believe you by Zoom.
Chavis.
I don't have an intern anymore.
I know. I wasn't used to hearing your voice.
It's going to be me.
It was a pleasant respite.
It was respite.
All right.
Could you please state your name?
What's it?
I think you said it.
Yeah, what's your name?
Justin Chavis. Sorry, the sound is so choppy right now. It's hard for me to hear.
Okay, no, it's okay. You're good. It's your attorney.
It is. It 1000% is. And Your Honor, we are asking for an adjournment. I did receive the offer yesterday, but we still don't have discovery, and I will get you a green sheet. Again, I don't have it.
You don't have a green sheet?
I don't have an
You
intern.
don't have an intern? You don't have a green sheet?
I know.
You don't know how to do anything.
I'm struggling. Just struggling,
baby.
Without objection, I'll adjourn this to April 30, 2026, 9 a.m.
Thank you, Your Honor.
All right, bond will continue. Said it for 8 years.
Thank you, Your Honor.
Thank you. Have a great day.
Likewise.
Court does call the case. People versus Kurt Bushline.
Good morning, Your Honor. J. Grant Miller, P58658 on behalf of Mr. Bushline.
Your name, sir?
Kurt Bushline.
Thank you. What are we doing?
Your Honor, I believe, have a plea in theory. I just didn't receive a form for Mr. Chebolowski, who is not present today. I know Ms. Feltis was covering it, and we were emailing last night. It's to plead a use, Your Honor. I just didn't get the form.
You. Ms.
I
Feltis,
apologize.
I know you're trying to cover a lot, so
I
I
wasn't
get.
clear on that from our email exchange that we were doing the plea today. So I apologize for not understanding that accurately. So I would request an adjournment of 1 week so we can get that done with the court's grace. Thank you.
I'll adjourn it out 1 week. April 23rd, 2026, 9 a.m. Bond continue.
Thank you, Your Honor. Thank you, Ms. Feltus.
Court calls case People versus Rashad at your Harshik.
Yeah.
Best I could. There's a lot of letters.
Agreed. Ready, Judge. Torres Feaster, Assistant Public Defender on behalf of my client. Please state your name for the record.
Good try. Okay. Go ahead. What's your name, sir?
Riada Zarpazic. Hadj Zarpazic.
Yeah, what he said.
Okay. No. All right. What are we doing?
Thank you, Judge. The last time we were here, I believe my client was in custody in a different county, and so we weren't able to address the matter, but it's been resolved now. So this is our first real PCC. One adjournment, Judge, so we can talk to the client and the people and see about a potential resolution.
Probable cause conference, 7/2026, 9 a.m. Bond on this will continue, and you don't have a green sheet because Shannon was supposed to do it, right?
Do what, Judge?
Okay. All right. Oh, we'll wait. All right. Thank you.
Thank you, Your Honor.
In touch.
Court calls the case People versus Jason Bryant.
Morning, Judge. Brian Bowling on behalf of Mr. Bryant.
How you doing?
Can you take the record, please?
Jason Bryant.
Thank you.
Judge, we're asking that this matter be set for an examination. I believe all discovery to be complete.
People have their witnesses available the 28th.
Your Honor.
Preliminary examination in person, April 28th, 2026, 9 a.m. before Judge Barr. Bond will continue.
Thank you, Your Honor.
Thank you. Court does call the case of this versus John Allen.
Yeah, yeah.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, representing Mr. Allen.
Your name, sir?
Dion Allen, sir.
Thank you.
Your Honor, we are requesting a preliminary examination, and we are also would like to address bond conditions.
Discovery is complete.
That's my understanding.
People have their witnesses available 28th. Preliminary examination in person, April 28th, 2026, 9 a.m. before me. As to bond.
Your Honor, it's my understanding that Mr. Allen is on GPS tether. We are requesting either the removal of the tether or a change in the exclusion hot zone from the address. Based on, it's our understanding, and Ms. Mackey did reach out to Ms. Zinda to confirm that the complainant is no longer at the hot zone address.
No, she will be at that address until, so I would be objecting to any modification of that until she is arrested.
Motion for modification is denied, given those circumstances. Thank you. Court does call the case of the people versus Kimberly Douglas.
People. Assistant Public Defender Chelsea Virgil with and on behalf of Kimberly Douglas.
Hello, Ms. Virgios. It's been a while.
Good morning. It has. Can you state your name?
Kimberly Douglas.
Good to see you, Your Honor. We are asking for an adjournment in this case. She has a pretrial in circuit court on April 23rd, so we ask for a date after that.
Okay. Probable cause conference without objection, April 30th, 2026, 9 a.m. Bond continued. Thank you. Court calls case people versus Malik Asadi. I was close.
Good.
All right.
You said perfectly.
Yeah.
Stephanie Cannon, on behalf of Mr. Al-Sidi.
That's exciting. All right. I have before me a plea form that indicates that he's going to plead guilty to the charge of disturbing peace in 90-day offense. Upon a successful plea to that charge, count one would be dismissed. That's the court's full understanding of it.
Yes, Your Honor.
Yes, Your Honor, that is my complete and full understanding.
May I have him sworn?
Right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth and nothing but God?
Yes, sir.
Name, please.
That's exciting. All right. Put your hand down. Sir, it is this court's understanding that you're going to be pleading guilty to the charge of disturbing the peace. That is a misdemeanor punishable by up to 90 days, $500 fine plus court cost. Do you understand that? Yes, Your Honor. All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court. You understand that? All right. Still wish to plead guilty? Yes, Your Honor. And to that charge, how do you plead? Good. You understand that by pleading guilty, you'll not have a trial of any kind? Yes, Your Honor. Signed an advice of rights form, is that correct? Yeah. Any question regarding any of those rights? Oh, Your Honor. Please look at paragraph 5. You'll see that copy shot on the podium, the rights which are part of a trial. And by pleading guilty, you'll be giving up those rights as well as all the rights on that. Yes, Your Honor. Then you're giving up your right to appeal outright. Yes, sir. Are you on probation or parole? No. Has anybody promised you anything other than what's been stated here today to get you to plead? No, Your Honor. Anybody threaten you or coerce? No, Your Honor. Doing this voluntarily and of your own free will? Yes, sir. And also because you believe that you are indeed guilty? Yes. On the date of September 14, 2025, at the location of 516 East Liberty Street, City of Ann Arbor, Washington County, State of Michigan, were you out in public? Yes, Your Honor. And was there a disturbance? Yes, Your Honor. Okay, what happened? We're out of a bar and we're all with friends and stuff, and we made a lot of noise. Yes, sir. And that it disturbed the peace and repose of the area immediately surrounding you. Sir, if I accept your plea, I do have to advise you if you commit misconduct between the time of my acceptance of your plea and the time of sentencing, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence recommendation or evaluation. You understand that? Yes, Your Honor. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
Your Honor.
I'm aware of none, Your Honor.
And have I complied with the court rule?
I'm satisfied, Your Honor.
Yes, Your Honor, I'm satisfied.
Court will accept the defendant's plea guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court. Probation sentencing will be
May 8th at 8:30.
May 8, 2026, 8:30 before Judge Perry. Bond will continue. Thank you, Your Honor.
Thank you, Your Honor.
Court calls the case of the people versus Russell Gull.
Feltes for the people.
Good morning, Your Honor. Assistant Public Defender Davy Leave on behalf of Mr. Gal. Gal, can you tell the judge your name, sir? Russell Gull. And Your Honor, I'd like to set this matter for preliminary examination, please. Discovery is complete.
Discovery is complete.
Yes, Your Honor.
People have their witnesses available the 28th.
You can track that, Your Honor.
All right. Preliminary examination will be set April 28, 2026, 9 a.m. before
Judge Barr.
Judge Barr.
Thank you.
Bond will continue. Thank you. Court does call the case of the people versus Melinda Baker.
Feltes for the people.
Michael Gaddy, Assistant Public Defender on behalf of Ms. Baker, Your Honor. He is here by Zoom.
Oh, there she is. Ms. Baker, can you state your name, please?
Melinda Baker.
Thank you.
Your Honor, may we approach very briefly?
Yes. Yes.
Why are they approaching? I don't like it.
as she's referred to as his wife. He loves her, begging for her forgiveness. So at this point, I'm going to be asking for his calls and texts to be revoked. He talks about what might happen with the case, if they come to court, if they don't come to court. So at this point, I'll ask for his calls and texts to be revoked.
That's any response.
No, this is my first time hearing about this. It's not too far.
Well, we'll get that to him. And at this point, I'm going to revoke the defendant's phone and texting privileges from the Washington County Jail. Right. Thank you. Court calls case People versus Shelby Barber.
People, Your Honor.
For the judge, court shall cease to assist public defender on behalf of Shelby Barber. Please
Your name? Shelby Barber. Thank you.
Thank you, Judge. According to our notes in the file, it looks like we are missing a second police report in this file. And so we're going to be requesting an adjournment so that we can get that second police report.
You know anything about that?
Yeah, Your Honor, my understanding is that the report is included in the media notice on this file, but I can get it routed to different way.
It's a different. Okay.
Thank you so much. Appreciate it. Thank you.
All right. I will adjourn May 7th, 2026, 9 a.m.
Thank you, Your Honor.
All right.
Thank you, Judge. Be in touch.
Court calls case People versus Larry Passaru.
Brian Bowling on behalf of Mr. Casaru, Your Honor. Can you state your name for the record, please?
Larry Casaru.
Your Honor, I'm asking for a preliminary examination in this matter. I believe all discovery to be complete.
All right. You have other witnesses available on the 28th?
Well, Your Honor, there is one uncharged case, which I think will be a misdemeanor that's slightly related to this. So I'll work on getting that police report disclosed to defense before that date, just so they have absolutely everything. But I think as far as the four corners of this case, we do have everything disclosed. There's just one more thing I'll get over there. Privately.
All right. That is my understanding. Thanks, Judge.
Preliminary examination, April 28, 2026, 9 a.m. That's before Judge Barr.
Thank you, Your Honor.
Thank you, Brian. Court calls case People versus Manuel Brandhouse.
Here, Your Honor.
Stephanie Cannon on behalf of Mr. Brandhouse, who is appearing by Zoom for Barnhouse. Mr. Barnhouse, could you please state your name for the record?
Manuel Barnhouse.
Your Honor, we're just asking that this be set for a preliminary exam.
The
Oh, and we also have to arraign him on the additional charge.
yes, on the additional charges, counts 4 through 7. Have you gone through that with him?
Your Honor, I have emailed him the information and we discussed it. Yes.
All right. And so as to the arraignment on counts 4 through 7?
Your Honor, my client would stand mute and ask for his next court hearing.
All right.
And we would waive the formal reading.
Defendant standing mute, or waiving formal reading, standing mute. Court will enter a not guilty plea as counts 4 through 7. I will oh, there she is. Ms. Johnson, can you state your name, please?
Kenyatta Johnson.
Thank you. All right, what are we?
Your Honor, we're asking for a preliminary exam.
All right.
I just believe I have all discovery.
We'll have their witnesses available the 28th.
We can try for that date, Your Honor. I will note there is a co-defendant who's also on the record this morning. So if that matter gets set, I will request the same date.
Okay, and that co-defendant is in what block?
This block, Your Honor. It should be one of the next out.
Your Honor, if I may, Assistant Public Defender Jay Bellinger, on behalf of Michelle Schaffner, who I imagine will be called next. Your Honor, we will not be setting that matter for preliminary examination today, just to let the court know.
Okay. Are they true co-defendants?
They are.
They are. Okay. All right. What do you want to do?
I'm wondering if the adjournment is because she's getting new counsel, and if so, then I'm going to ask to adjourn.
Oh, okay.
Yes.
So
Okay.
your case, new counsel's coming in, Mr. Bellinger.
My client is seeking new counsel, Your Honor. She no longer wishes for representation from our office, and I'll make that record next.
Gotcha. Let me do this with your case, Johnson. I'm going to adjourn your case for PC 30th.
Okay.
Thank you.
And then let's try to, if they need to be together, let's have them together. Okay. Okay, Ms. Johnson?
Okay. Your Honor, I'll make a motion for Ms. Johnson to be allowed to travel out of state.
Where's she want to go?
To Atlanta for her niece's graduation from May 20th through the 27th, which she will be flying.
Her niece is graduating?
Yes.
From where?
She goes to high school in Gwinnett County in Logan'sville, Georgia.
Oh, okay. So she's graduating from high school.
Not Spelman graduate yet.
What did you say?
Not Spelman graduate yet.
Why did you say Spelman?
Because it sounded right.
I was actually wondering. I was wondering only because my sister graduated from Spelman. So
Seeds.
And I didn't like how they blew and white. So if she's going there, I was going to let her go. No, I'm kidding. All right. What are the dates you need to travel, ma'am?
May 20th through May 27th. And I do have her flight information.
That's all right. All right. No objection. I will allow travel to Atlanta from the 20th through the 27th of May.
Thank you, Your Honor.
Thank you, Your Honor.
I will set this for the 30th, 9 a.m. Bond will continue. All right. Thank you. Thank you, Ms. Johnson.
Thank you. Thank you.
Courthouse case versus Michelle Schaffner.
Ashley Feltus for the people.
And Assistant Public Defender Jay Bellinger on behalf of Ms. Schaffner, who appears via Zoom. Ms. Schaffner, can you please state your name for the record and unmute, turn on your camera?
Michelle Schaffner.
All right. You're asking for an adjournment?
Your Honor, I would be asking.
Go ahead.
I would be asking for an adjournment to the 30th as well. I will make it clear for the record that there has been an offer made on this case. I would ask that that offer stay open for the time being. We were intending on setting for a preliminary examination today. However, Ms. Schaffner just informed me that she no longer wishes for our office to represent her, so she would be seeking new counsel on this. I don't believe she intends to retain.
You don't believe she intends to do what?
To retain. I don't believe she intends to retain.
Okay. Ms. Schaffner, is all of that correct?
Correct.
So you're intending on getting new counsel?
Yes, I just want a different person. Me and him, we don't see eye to eye. I feel.
That's usually because the client's not listening, but that's okay. Here's what I'm going to do. I'll adjourn the probable cause conference to April 30th, 2026, 9 a.m. That's for you to seek counsel. That's the only adjournment you'll get for that purpose. Bond continued. Thank you.
Thank you, Your Honor.
Court calls case Reva versus Thomas Sebastian.
On behalf of people.
With Judge Portiel Feaster, Assistant Public Defender, on behalf of Mr. Vasher, who's the first on the podium. Mr. Vasher, please state your name.
Thomas Vasher, correct.
Thank you, Judge.
I'm sorry.
I think we're ready to try and move this matter forward. If we could set this matter for preliminary examination, these matters for preliminary.
All four of them?
Sure.
So discovery is complete. Will the people, this is available the 28th. Preliminary examination in person will be set
April 28th, 2026, 9 a.m. before Judge Barr.
Thank you very much, Judge. He's not going to give you a phone.
Thank you.
The bond continues.
He's not going to give you nothing back. Well, thank you, Judge.
Thank you. Court calls case People versus Alan Fry.
Ashley Feltus for the people.
I'm sorry, Fry. Thank you.
Brian Bowling on behalf of Mr. Fife, Your Honor.
Good morning, Your Honor. Alan Fife.
All right.
Judge, we're asking for another adjournment. We're continuing to have some ongoing plea discussions. Kind of still waiting for management to kind of give us some direction. So.
We are requested, Your Honor.
Okay. We'll adjourn it. Will May 7th give you guys enough time to?
I would hope so.
Probable cause conference, May 7th, 2026, 9 bond continue.
Thank you, Your Honor.
You're getting to be quite the star on TV, Your Honor.
Pardon?
You're getting to be quite the star on TV.
Is that right?
Yes, I saw you again yesterday.
I don't watch TV. No, I'm kidding.
Thanks.
Thank you for that, sir.
Thank you.
Court calls case of the People versus Jamie Gurney.
Ashley Feltus for the people.
Assistant Public Defender Chelsea deals with and on behalf of Jamie Gurney. Please state your name. Jamie Gurney.
Thank you.
I have a green sheet here, Your Honor. We're asking to adjourn for a plea discussion. Is it possible to get 3 weeks, Your Honor?
May 7th. Will that work? That's 3 weeks.
Yes, please.
All right. May 7th, 2026, 9 a.m. Bond continued. Thank you, ma'am.
Your Honor.
Thank you, Your Honor.
Court calls case of the People versus Jason Haas.
Ashley Feltus for the people.
Here's mine. Okay, the blue tick. 3 hours.
Thank you, and on behalf of Mr. Haas, please state your name.
John Honest.
All right, I have before me a plea form that indicates that the defendant is going to be pleading guilty to the charge of operating while intoxicated, second offense.
That is correct, Your Honor.
On a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding.
Yeah. Yes, Your Honor.
May I have him sworn?
Right here. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the help you God.
I do.
State your name.
Jason John House.
Sir, it is this court's understanding you're going to plead guilty to the charge of operating while intoxicated, second offense. That is a misdemeanor. It is punishable by up to 1 year incarceration, 90 days community service, up to $1,000 fine plus court costs. The court can also order rehabilitative services that the court deems necessary. Court could also order your vehicle immobilized, could order you to pay the cost of prosecution, cost of any emergency governmental services. You understand all of that, sir?
Yes, Your Honor.
All right. Still wish to plead guilty?
Yes, Your Honor.
To that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
All right. You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any questions regarding any of those rights?
No, Your Honor.
Please look at paragraph 5 on that form. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised anything? Bless you. Has anybody promised you anything other than what's been stated here today on the record to get you to
No, Your Honor.
plead? Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will,
Yes, Your Honor.
and because you believe that you're indeed guilty of this offense?
Yes, Your Honor.
April 28, 2025, at the location of South Maple Road in Ellsworth, in Pittsfield Township, Washtenaw County, State of Michigan, you operating a motor vehicle.
Yes, Your Honor.
Prior to operating that motor vehicle, had you consumed intoxicating liquor as well as ingested controlled substances?
Yes, Your Honor.
What were those?
I think methamphetamine, the opiates that were on the list, I think that was from the ambulance.
Consume fentanyl.
I think that was the ambulance.
Pardon?
I think that was the ambulance, like, yeah, because I don't really do that.
Your Honor, there was an accident and when he got in, they gave him medicines. So he is acknowledging that he took
Methamphetamine.
Methamphetamine
and
time prior to.
Yeah, and weed and.
Okay, had you smoked marijuana or ingested marijuana?
I used to, yeah. This is, yeah.
Yes, at that time, yes.
Okay, let me make sure I'm clear. Had you ingested or taken marijuana or THC prior to operating that motor vehicle?
Yes, Your Honor.
All right. And had you also drank?
Yes, Your Honor.
All right.
That impair your ability to drive?
Why are you asking that? Were you, was there an accident?
Yes, there you go.
Yeah, but it was more, yes.
You had an accident. The police came, correct?
Yes.
They took you to the hospital?
Yes.
And there was a blood draw?
Yes.
And the results of that blood draw showed the presence of methamphetamine, marijuana, and the alcohol. Is that correct?
Yes, Your Honor.
Do you have any reason to dispute those blood test results?
Oh, Your Honor.
What happened with the accident? Do you recall?
It was kind of like a suicide attempt.
Okay. So you purposely crashed into something?
No, I was just driving recklessly, like, because I was angry and sad.
When was this?
Had you previously been convicted of operating while being intoxicated on or about March 15, 2019 in the 44th Circuit Court?
An OWI, is that what you were asking?
Yes.
Yes, Your Honor. I had one back in
2019.
Yes.
All right. Sir, if I accept your plea, I do have to advise you that between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined in the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not make a recommendation or evaluation. You understand that, sir?
Yes, Your Honor.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
Your Honor. I'm aware of none, Your Honor.
Have I complied with the court rule?
Or satisfied. The court has.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation as well as screening and assessment is ordered at 14A1 probation. Sentencing in this matter will be
13th at 9 a.m.
May 13th, 2026, 9 a.m. That is before me.
Your Honor, the probation department here, he can go there today, correct?
You can go right to the probation department, correct?
Thank you,
We
Your
give
Honor.
them instructions to meet with Bond Swartz. Bond will continue. Thank you. Court calls case of the People versus James Kearney Jr.
Judge Feltus for the people.
Assistant Public Defender Duffy Lieb on behalf of Mr. Kearney, who appears via Zoom.
He is not here.
Your Honor, I did speak to him yesterday. I do know that he's currently recovering from an injury.
What do you mean?
He was shot, Your Honor. I know that to be true.
Got it.
He's been in the hospital, I think, throughout some of this case, but I think he is now out of the hospital.
He is. I think he was just very recently released. So perhaps there was some issue with when the Zoom went out. I can call him if you could pass the case, Your Honor.
Why are you guys asking me? You know, I've only Are you asking me to pass this case so you can call? All right, I'll pass it. It's the only person I'm doing it for.
Thank you, Mr. James.
Court calls the case, People versus Frank Kyle.
Judge Feltus, people.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Kyle, who should be present in person.
Nope.
And Your Honor, unfortunately, Mr. Kyle also has a community correction site.
Does.
I think there's already a warrant. Not, I'd ask that one be issued.
And I did have a conversation with Mr. Kyle yesterday just to inform the court. I was anticipating that he would be here based on my conversation with him. So I have there's nothing to justify his absence.
All right, I actually issued a bond with or a warrant with no bond.
Thanks, Your Honor.
So I'm going to leave the bench warrant out. Standing.
Thank you.
Court calls case People versus Melvin Lilly.
Ashley Feltus for the people.
Brian Mulligan, behalf of Mr. Just state your name for the record, please, Melvin. Melvin Lilly.
Thank you.
Your Honor, we're asking this matter be set for a preliminary examination. I believe all discovery complete.
And the people have their witnesses available the 28th.
Prior to that date, Your
Preliminary examination in person, April 28th, 2026, 9 a.m. That is before for me. Bond will continue.
Right. Same place. Thank you, sir. Thank you, Judge.
Court calls case People versus Robert Lowry.
Feltus for the people.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Lowry, who appears via Zoom. Mr. Lowry, can you please state your name for the record?
Robert Lowry.
Thank you.
And Your Honor, I'm just seeking a couple weeks on this matter to get some information over to the prosecution.
All right. Probable cause conference without objection will be adjourned May 7th, 2026, 9 a.m.
Thank you very much.
Bond
Thank you, Your Honor.
Thank you, sir.
Have a good day.
You too. Court calls case People versus Kenneth Mays.
Feltus for the people.
Morning.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, representing Mr. Mays. Would you state your name, please, sir?
Yes, sir. First name is Kenneth, last name Mays.
All right. What are we doing?
Your Honor, we are requesting an adjournment. We requested some additional discovery and are asking for a short adjournment so that we can go over that with our client.
You see his progress report?
No, Your Honor.
On the 10th, tested positive for cocaine, amphetamines, and THC. And then 5 days later, he's testing for the amphetamine and THC.
Could we have a few moments to discuss the report, please?
Well, you're going to be requesting an adjournment?
I'm just asking to pass it for a few moments right now.
He's not to leave the courtroom. Take your hand out of your pocket.
Yes, sir. No problem, guys.
All right, I'll let you talk, Ms. Gaines.
Thank you.
Pass it briefly. Court calls case People versus Ryan Miller.
Now we have the people.
Joy Gaines, Senior Assistant Public Defender. Your Honor, I had called Mr. Miller's name in the courtroom without any response, and we were not able to get in touch with him prior to today's hearing. I think he might possibly be at the Delonis Center. I would ask for a short adjournment to try to get in touch with him.
Bench warrant will issue. Found 10,000. That warrant will issue immediately. Court calls case of the People versus Matthew Forson,
People.
aka Esther Murphy.
Assistant Public Defender Chelsea Virgils on behalf of Esther Murphy, formerly Matthew Morrison. Your Honor, I haven't had contact with this client.
Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of 10,000 cash surety. That warrant will issue immediately. Court does call the case of the People versus Dion Nelson.
Ready, Judge. Court shall feast their Assistant Public Defender on behalf of, but not with, Mr. Deion Nelson. Your Honor, we've called and tried to find Mr. Nelson. We do not know why he is not present. For the record, we request an adjournment.
Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $10,000 cash.
Thank you, Judge.
Thank you. Court calls case people versus Deshaw Patterson.
Calls for the people. This game.
On behalf of Ms. Patterson, please state your name for the record.
Deshaya Patterson.
Okay.
Your Honor, we were unable to reach Ms. Patterson prior to today's hearing. We're asking for Ms. Meehan in order to get some additional, have a chance to talk to her about her case.
That objection, probable cause conference, May 7th, 2020, 9 a.m. Bond continue. Thank you. Thank you, ma'am. Court calls case people versus Leo Stringa.
Actually, calls for the people.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Stringer, Your Honor. I submitted some documentation that Mr. Stringer was released from the jail and taken directly to a treatment facility. And I'm requesting an adjournment, Judge.
It's a 20 up to a maximum of 30 days. And this letter's the 15. Okay, so what I'll do is I'll grant the adjournment. I'll adjourn it to May 21st.
Thank you.
2026, 9 a.m. Bond continued. Court recalls case viewers, Deborah Collette.
Calls for the people.
Have you let all the people in?
Assistant Public Defender Chelsea Vergils with and on behalf of Deborah Collette, who appears via Zoom. Ms. Collette, please press *6 to unmute. And state your name once you're unmuted.
Ms. Collette? Ms. Collette, could you hit *6 on your phone? We were sure that was her.
Yes.
Ms. Collette? You're referring her for sobriety court.
Yes, Your Honor. I apologize. I know she tried for a very long time to get logged on with video and wasn't able to do so.
And she was, okay. I get it. What I'll do is I'll adjourn probable cause to May 7th, 2026. I think that's her. And we can't send her a message, so maybe somebody can try to reach out to her. But I'll just adjourn it now.
Thank you, Your Honor. And just for the record, I did see prior to the name change, it was her phone number that I spoke to her on today that appeared on the scene.
Thank you.
Thank you, Your Honor.
Court calls the case, People versus Gregory Jones. Recall.
Michael Gaddy, Public Defender on behalf of Your Honor. Thank you for calling better. Mr. Jones, after some technical difficulties.
Yes. Mr. Jones, can you state your name, please, sir?
Yes, Gregory Jones.
Thank you.
Your Honor, we'd ask to set this matter for exam.
Discovery is complete.
Yes, Judge, to the best of my knowledge.
People either went available the 28th. Preliminary examination in person for 28th, 2026, 9 a.m. That's before Judge Barr.
Thank you, Judge.
Thank you. Bond, continue. Thank you. Thank you, sir.
Thank you.
Court recalls case Bill versus James Kearney.
Feltus for the people.
Assistant Public Defender Davi, leave form Mr. Kearney. Unfortunately, I was not able to reach Mr. Kearney, although I do appreciate the court passing the matter.
You need to thank Mr. Gio.
Thank you, Mr. Gio.
Because I wouldn't have done it. Bench warrant will issue in this case 10,000 cash surety. That warrant will issue immediately.
Thank you.
Thank you.
And recall the case of the people versus Kenneth Mays.
Josh Feltus for the people. Union Assistant Public Defender. The on behalf of Mr. Union.
Thank you for those moments. For those for us. Let me talk about the report. Your Honor, in speaking to Mr. Mays, he acknowledges that the first test result of April 10th was immediately after he was arrested and released from the Washtenaw County Jail. And he does acknowledge having used a substantial amount of substances prior to his arrest. And his testing was within 24 hours of using those substances. And so we'd like for Your Honor to focus on the next date, which clearly shows that he has not continued to use cocaine. There is not a positive for cocaine. He is working on getting the marijuana out of his system. He indicates that he has been a heavy marijuana user. We are not clear about the amphetamines, but he is very open to going to substance use treatment. He recently obtained employment and he's currently working. If the court would give him the opportunity to try to maintain his employment and go to some sort of intensive outpatient treatment, he would be very, very much appreciative of that and is willing to test if the court wants more frequently. Is that fine with you?
Absolutely. So he's admitting to the violation as to at least the fifth.
He is indicating that there's definitely would still be some marijuana in his system based on the.
What about the amphetamines?
We have no explanation for the amphetamines.
So does he want a hearing on that, or what does he want to do?
Would you like a hearing? Would you like a hearing on that? Oh, it's something more cool.
I use your judgment. Yeah, and I've been fighting hard to put things back together, and just brought the opportunity for me to change things around in my life. To successfully gain employment. I had previously experienced a lot in life, as far as life-changing situations, finally the direction to put things in a better direction. Am I wrong for doing the things that I have done? Absolutely, Your Honor. It's just been a hard fight, last few years. Saying some life-changing situations, to where life just wasn't the best. I want to kind of put everything out there, but I fought self-defense murder, and I was able to overcome it. And it has been, just mentally just a challenge. And just as I started to, want things to come better for myself, I just looked at this opportunity of me clearing up things that I've done in the past to move forward. Am I right did I make the right decisions? Absolutely, I did not. I accept all accountability for my actions. I just believe that me being incarcerated right now just sets me back further from going into a better positive direction.
So with that, it doesn't sound he is not looking to adjudicate the issue, and he acknowledges that he has a substance use problem and is just asking for another opportunity.
I have been fighting. Whatever, they'll adjourn this matter out 1 week and try to figure out something, but to April 23rd, 2026, 9 a.m. If he wishes a hearing, let the court know and we'll set it at the time, but he's, at this point, his defendant remanded. Well,
Yes.
that's it for that block. Give a break. All right. Court's inspiration. All right.
Was a blood test case. My client is currently on a stram tether, no violations or anything. He was arrested at an airport. Him and his wife own a travel and tour company. And because he wasn't aware that the warrant came out because the blood test took a while to come back. They're at the airport. He gets arrested at the airport. When he was arraigned, because he was at the airport, they told him he had to turn in his passport. He's an American citizen. No issues with that. So what my bond...
that matters. I'm sorry.
It's so true.
I am
not matter.
Go ahead.
Good commentary, Governor. So what he'd like to ask the court to amend his bond to travel for him and his wife's business. He has no problem with taking the I told him TSA may have a say if the judge grants that amendment, but TSA may not let him travel with that tether. And if so, then he can't travel. But he would request that Chelsea PD turn back his passport and allow him to travel to the Caribbean to do tour. They do site visits, him and his wife's company.
Okay, so all right. As I'm hearing you, there are two issues. One, he needs his passport back. Right.
Correct.
And then the other would be the ability to travel for business.
Correct.
All right. Do people have a position?
Yeah, as long as the scram tether continues, I have no objection.
Let me ask this. Sometimes we have problems, sometimes we don't with the scram tether. Was the scram tether a problem? Well, he hasn't been he hasn't done it.
Correct.
Defendant's bond will continue. I will permit the defendant to travel for business purposes. So that, sir, that you know that you'll have to provide proof if questioned by the court regarding. Okay. I also will specifically order you to put that on there that Chelsea, you said Chelsea PD has it?
Yeah, and I'll reach out to Detective Gilbert. They told him that they were going to send it here, but I don't believe they have. I know
here
his passport, but I know that sounded strange to me when he told me that. So I can follow.
So hold passports. It's usually held by the police agency. So if they tried to give it to us, we would give it back to the police agency. All right. So let's do this. And I'll order it this way. If the Chelsea Police Department is still in possession of his passport, I'll order that they return that to the. Yes.
All right. Thank you, Your Honor.
Should it? Thank you. Thank you.
I will get it.
All right. Court calls case People versus Jennifer McCready.
Ashley Feltus for the people.
Good afternoon, Your Honor. If you can hear me, this is Matthew Mansour on behalf of Miss Jennifer McCready, who appears via Zoom today. Jennifer, can you please unmute, put your camera on, and state your name for the judge?
There we go. Sorry. This is Jennifer McCready.
Okay, there she is. Yeah.
This is Jennifer McCready.
Yes. Okay, correct. Well, yes, ma'am. Thank you. All right, what are we doing?
Thank you, Your Honor. Today is the date and time set for a probable cause conference. I believe discovery is complete. We would like to set this matter for preliminary examination, please.
We'll have their witnesses available the 28th.
We'll track that date, Your Honor. Thank you.
Preliminary examination in person will be set April 28th, 2026, 9 a.m. before me.
Thank you, Your Honor.
Bond will continue. Thank you. Court calls case of the People versus Demetrius Caldwell.
Ashley Feltus for the people.
And good afternoon, Your Honor. Sydney Rushing appearing on behalf of Mr. Caldwell. Your Honor, I believe Mr. Caldwell is still in custody.
In custody where? You told me you were going to be here today.
No, I didn't.
Yes, you did.
When? When did I say that, Judge? If I did, I apologize.
You told me that.
Judge, I don't recall saying that. Usually I'm there if I am.
Thanks for sticking up for me, Ann. Wow.
Judge, I believe he's in the Washington County Jail. We were waiting on a competency report. I just received the report this morning in the mail. It was in my mailbox this morning. So I'm just seeking a 1-week adjournment just so I can talk about the report with him and then the court can enter it.
That's fine. Is he in our jail?
Well, this morning, I think we had this conversation. He wasn't. XGL shows him having posted bond.
So XGL shows him posting.
Okay, Judge, I wasn't aware that he had posted bond and his guardian, I hadn't heard anything from his guardian stating that they had posted it or anything. So
you want me just to put it out a week?
Please, Judge, that'd be greatly appreciated.
All right, are you going to be here or no?
Judge, depends. If I have a trial next week or not? No, I'll come in person. I'll come see you next week, Judge.
Okay. So it's okay. I don't mind being second fiddle.
It's not second, Judge. Not second at all.
No, it is. It is, and I'm hurt. What's sweet? April 23rd, 2026, 9 a.m.
Thank you, Judge. I'll see you next week on that one.
Oh, don't promise me things you won't keep. Bond continue. All right. Thank you, Ms. Rushing. Court calls the case People versus Rachel Pichette.
Ashley Feltus for the people.
And good afternoon, Your Honor. Sydney Rushing appearing on behalf of Ms. Pichette. Ms. Pichette, can you state your name for the record, please?
Rachel Pichette.
Thank you. Your Honor, we are just seeking a very brief adjournment on Ms. Pichette's matter. The outstanding misdemeanor matter that we were working with resolved yesterday. I do believe we have a resolution in this, so paperwork just needs to be submitted. And I think we're just waiting to see if there's any digital. I have paper. It's an older case, so I'm not sure if there's digital or not, but I believe we have a resolution.
All right. So if I put it out a week, you'll have the paperwork in to do whatever you need to do, or no?
Yes, Judge.
All right. Probable cause conference will be set for April 23rd, 2026, 9 a.m. Bond continued.
Thank you so much, Judge. Have a great day to you and your wonderful staff.
You do the same.
Thank you. Thank you.
Court calls the case People versus Rebecca Dooley.
I should tell this to people.
Good afternoon, Joe Simon on behalf of Ms. Dooley. Ms. Dooley, state your name.
Rebecca Dooley.
Your Honor, this is the case that Mr. Cook and I approached you about a couple of weeks ago. The people, I believe, are going to move to remand the matter on an OWI second to your Honor's docket for a date for pretrial after April 18th, as the court may remember why.
All right. So that's what's happening today.
That would be my motion to remand it on that added count. OWI the second. I do not have an amended blank. I apologize, Your Honor, but I can give the court one.
Okay. So here's the way I'll do it. Well, so the other two are felonies right now.
Right.
They're going down on on count 2 or no?
I believe what Mr. Cook had said was he was going to, we can, because we can pre-try that, Your Honor. How's that?
We ran out of count 2 with an added count 3 of OWI second.
All right.
It's missing count 1 in this time.
So what I'll do is I'll continue his plea to count 2, wait for presentation of the complaint as to a count 3 of OWI second. We'll dismiss count 1. And the pretrial date needed to be after the 18th, was it?
Correct.
Of April? Or
that's correct.
Okay. May 6th, will that work?
I'll make it work. Thank you.
May 6th, 2026.
9
a.m. Before me. Bond will continue.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
Both. Court calls the case People versus Ahmad Isa.
Joe Simon on behalf of Mr. Isa. State your name when you get up here, Ahmed.
Ahmed Isa.
Thank you, sir.
Your Honor, this matter we're requesting for a preliminary examination, please.
All discoveries complete.
Yes.
Will have the witnesses available to 28.
Your Honor,
no, go ahead, sorry.
That's a terrible day for me, but I'll make.
I don't care.
I want my
work. That's okay. No, go.
Expediency is important for him for a couple of reasons. Let's just keep it there. Let's do the 12.
Will that work?
I'll make it up.
You will. All right.
No,
you want a different date, Mr. Simon? I mean,
I did, but the next available is the 5th. My client's going on his honeymoon on May 6th. Which we're going to ask for permission to leave before. But we hope
it's not doing it.
We hope
you're going to flew right past it.
We hope this might reach a dispositive resolution on the 28th. That's why I think it's better to do it on the 28th.
Honeymoon.
Oh,
that's all right. Preliminary examination will be set April 28, 2026 at 9 a.m. before me.
Thank you.
And did you want to ask to go on that now or?
Yes, I think it's only appropriate. He's not actually going to a very elaborate destination, but he wants to leave the state from May 6th to May 18th. Yes.
Well, now we got to know where he's going.
We're going to Florida May 6th for my wife's graduation. from UCF, and then from Florida, Orlando.
Central Florida?
Yes.
I hate them. They're the nice. Don't they? Okay, go ahead.
And on the 10th of May, we will go to
Where?
Antigua, an island.
Oh, yeah. Oh, I know. Really?
Oh, okay.
I just didn't.
So the 18th.
All right. I will. So the dates are.
May 6th to May 18th.
So I will just indicate that the defendant may travel out of the state of Michigan from December 6th through the 18th. Those include your travel days, sir.
Mhm.
Okay. All right.
Thank you, Honor.
You're welcome.
You can go home. You can wait if you want.
Okay. Thank you.
Court calls the case of first John Lenz.
Well, the people, I do not have a response.
Okay. Council approach.
Okay.
Thank you, Honor.
Thank you. I have before me a plea sheet that indicates that the defendant will be pleading to an added count 3 of operating while intoxicated, second offense, a 1-year offense. Upon a successful at sharp counts 1 and 2. This defendant is also to enter into and participate in the court sobriety court program. That's the court's full understanding of.
That's completely correct, Your Honor.
That's correct, Your Honor.
May I have him sworn?
Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Name.
John Lenz.
Sir, it is this court's understanding. We're going to be pleading guilty to the charge of operating while intoxicated second. That is a.
Yes, Your Honor.
That is a misdemeanor punishable by up to 1 year incarceration, communities, and a $1,000 fine plus court costs. The court could order community service and any rehabilitative programs the court deems necessary. Could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that, sir?
Yes, Your Honor.
All right. Sir, you also understand that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Freshour in the Gene A3 District Court. Understand that?
Yes, Your Honor.
All right. Still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
You understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
All right. Signed in advice form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal upright.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today to get you to plea?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily?
Yes, Your Honor.
Of your own free will?
Yes, Your Honor.
And because you believe that you're guilty of this offense?
Yes, Your Honor.
December 18, 2025, at the location of Riker Road near Stillwater Drive in Dexter Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes, Your Honor.
What'd you have and how much?
I had roughly 3 to 4 shots and about 10 or 11 beers.
Were you stopped by the police or was there an accident?
I was stopped by the police.
Okay, why'd they stop you?
I was asleep at the wheel.
Were you ultimately arrested?
Yes, Your Honor.
You were taken to the hospital for a blood draw?
Yes, Your Honor.
And what were the results of the blood draw?
0.232.
You don't have any reason to dispute those test results, do you, sir?
No, Your Honor.
All right. And had you previously been convicted of operating while intoxicated on or about January 12th, 2018 in a Kentucky court, and or of operating while intoxicated on or about June 29th, 2021, also in a court in Kentucky?
Yes, Your Honor.
Sir, I do have to apprise you that if you commit misconduct between the time that I accept your plea and the time of your sentencing, that misconduct is defined by the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes, Your Honor.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court?
You are satisfied.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 3. Counts 1 and 2 are dismissed. I'll indicate a pre-sentence investigation is ordered. However, most of that's been done since he's going to be sentenced in